for delivery of judgment, WPC 392/2024, Srimati Joyanta Maibangsa versus the State of Assam.
The petitioner is entitled for compensation. That's a settled position. Even before the trial or during the pendency also, there are so many judgments. So she is entitled for compensation. But as a palliative measure, as is decided by the larger bench of the Honorable Supreme Court. So as a palliative measure, we have decided to award her 20 lakhs as compensation, plus 5 lakhs she got during the pendency. So 25 lakhs as compensation. That is in addition to her remedy under the private law, as well as 357 by the criminal courts. So we have decided 25 lakhs in total. Okay.
May I please, Lord? May I pray for listing on day after tomorrow, madam?
Just give it to the court master. He'll have to make some adjustments.
For
Give it to
withdrawal of the petition.
Whatever be, just give it to them. They'll
But
try.
publish. I have a similar
All
prayer.
prayer for listing, please give it to the court master.
May I please, Your Lordship? Lordship, the small prayer regarding item number 60 of orders column, Lordship, supplementary list.
Yes.
Lordship, kindly take up the matter at 2, Lordship, 2 o'clock. Lordship.
If we reach before 2 also.
Yes, Lordship.
Okay.
Obliged, Lordship.
If I may, my lord, I beg to mention item 13 of the daily list.
30.
13, no.
13.
My lord, this is a freshly filed matter, my lord. Mr. A. Iqbal would be appearing, my lord, but he's unwell today. My lord may fix it on Monday if possible, my lord.
Item 13, you said?
Yes, my lord.
Okay. List on Monday will be 8/6/20, paid for by land council for the petition.
Deeply obliged.
Similar prayer for item number 11, Lordship. I'm on behalf of A. Islam, Lordship. He's not well. So on Monday, Lordship.
You have informed the other side?
Lordship. I'm informed, Lordship.
Okay. Item 11.
11.
Okay. Both sides are represented on the prayer made by land council for the respondent caveator. List on same 8/6.
Item number 46, my lord. I may be allowed to withdraw this item, this case, because the party has decided to amicably settle outside the court.
Other side is there?
Other
Yeah,
side.
there. Okay. Mr. A. Upadhyay, land counsel for the petitioner, and Mr.
A. Chetri appearing for R. Ali.
A. Chetri, land counsel appearing on behalf of Mr. R. Ali for the respondent is present. Next, for instructions, the land counsel for the appellant has submitted that the parties are trying to settle the matter outside the court. And therefore, he has instructions not to press this appeal. Not to press or to withdraw? Withdraw. To withdraw the appeal. So there is allowed, the matter stands dismissed on withdrawal. Okay. Interim order, just check it out. If there is any interim order, that could be withdrawn.
All right.
May it please your lordship?
Just wait. Senior is there.
My lord, I crave your lordship's indulgence to mention 2 items. My lord, I was out of station. I reached late night. Item 10, my lord, on Friday.
Item 10.
On Friday.
Item 10. List on 5/6/2023, paid for by besides the the senior counsel for the petitioner.
And in regard to 15, my lord, I have taken consent of my learned friend. Let it come after 2 weeks, my lord. I did not get the papers we have sent to my client. I'm waiting for that.
15. Due date after 2 weeks. Votes as a representative on the prayer made by Mr. S. Datta, the senior counsel for the petitioner. List on
My lord, interim order may continue.
intimate custody stands extended to the next date of
19.
Much obliged.
May it please your lordship. Your lordship, I beg to mention item number 65 of supplementary list, my lord. Your lordship, in this matter, we were represented for respondent number 2 and 3. Two is the husband and 3 is the wife. Respondent number 2, the husband died on 26/5/2026, my lord, leaving behind his wife and a daughter. So the daughter's name has to be substituted. So kindly,
Okay,
lordship, the date may be.
number 2 has died.
Yes, lordship.
He has died on which date?
26/5/2026.
Is the appellant present? My lord.
No.
Okay.
We have informed the other
Mr.
side.
K. M. and counsel for the appellant is present. Miss
S.C. Murtaja on
S. T.
behalf,
Murtaza and counsel appearing on behalf of
Miss R. Chaudhary.
Ms. R. Chaudhary, the senior counsel for respondents 2 and 3, submits that as per instructions received by her, the respondent number 2 has expired on 26/5/2026, leaving behind his wife and a daughter.
Yes, lordship.
Accordingly, the counsel for the respondent numbers 2 and 3 have discharged their duty under order 22 Rule 10 capital A of the CPC. Most of the learned counsel for the appellant shall take note of the same and and take appropriate steps. Matter stands adjourned today. List after 2 weeks.
Much obliged.
My lord, item number 22 is an order matter, my lord. My lord, in this case, my lord, I was directed to take steps by furnishing amended cost title. I have filed it today, my lord. I failed to furnish it as directed by this honorable court within time. So, my lord, as that amended copy has not come, may I pray for listing it on 17th, my lord. On the 17th, I have another matter fixed before lordship.
Mr. Chauhan is there, other side?
I have informed him, my lord.
You can call him, okay. With information to the other side, Ms. B. Chaudhary, learned counsel for the petitioner, submits that the amended cost title has been filed today.
This morning.
Huh?
This morning.
Today, the same is not on record, so accordingly, the registry shall tag this amended cost title on record. Next, but as paid for by the learned counsel for the petitioner, list on
17th, my lord, for orders.
76. Okay, 2026.
I'm obliged, my lord.
Maybe. To the consent of the other side, I beg to mention item number 17, my lord.
17,
17, my lord.
yes.
And it take up the matter next week, my lord, any date, my lord.
Okay. Also, as a representative on the prayer made by Mr. A. Azhar and counsel for the respondent. List on the date after 2 weeks. Okay.
How large? May I please?
Chief, I beg to mention item number 29, my lord, in concern of the other side, my lord. Item number just to adjourn, my lord, list after 2 weeks. my lord.
29, why the matter is listed today?
My lord, actually, we have to file a substitution petition, my lord, but my lord, we have to file substitute the petitioner, my lord. But my lord, the problem is that when one of the legal my lord deciding is outside Assam, my lord, due to my lord, that my lord, we could not be filed. Some more time, my lord, please.
Okay, you have informed Mr. Mahanta?
Just Lord, for the.
Oh, you're there. Okay, both sides are represented. Mr. K. M. Hassan, learned counsel for the petitioner, submits that steps for substitution could not be taken till date and therefore pays for adjournment. Prayer is allowed. Matter stands adjourned today. List after how much time?
My lord, 3 weeks, my lord.
3 weeks will be very close to vacation, we will not be able to take up. Fix it on 19th.
My lord, 19 means after 19, my lord, any date,
No,
20,
you
22,
see,
23.
we'll be very close to vacations, we'll not be able to pass these
Then my
orders.
lord, 17, 18, maybe. 17,
Okay, 7,
17. Oblige.
make it 16.
My lord. Oblige.
Wait, please. I beg to mention item number 11, madam.
When somebody has already taken an adjournment,
That's all right. When it is fixed.
huh?
It's on
8th of June, somebody has taken an adjournment. It was without your consent. It was without your consent.
No, he has to
It-
consent
taken-
my
taken-
consent.
Okay, okay.
For withdrawal, item 1.
May I please, your lordship?
Yes.
On the instruction of my client, I want to withdraw this case, lordship. The parties have compromised.
Okay, your name?
My name is B.V. Gauhati.
Mr. D.V. Kakatil, and counsel for the petitioner submits that he has received instructions that the matter has been compromised outside the court, and therefore he has instructions not to press the matter. Accordingly, matters are dismissed from withdrawal as paid for.
Oblige.
Okay, the interim order passed earlier on 25/7/2025 and reported.
For withdrawal, item 2.
May I please, your lordship? Lordship, what happened in this case was at the time of filing, the file contained two copies, one drafted copy and another was the final copy. And at the time of filing, the drafted copy was filed. So I may be allowed to withdraw this case with the liberty to file afresh.
No, I did not get it. What did you file?
The drafted copy actually was filed, whereas the final copy was not filed. Actually, in page number 10, there are blank spaces which ought to have been filled. And the other thing is the schedule was also not provided there.
Okay. Mr.
Yes, Afridi.
Yes, Afridi, Learned Counsel for the petitioner submits that the petitions contain some inadvertent error as some portion of paragraph 9 is left blank,
There was a mistake in the synopsis also.
and there's also mistake in, there was a typographical error in the drafting. Accordingly, there is liberty to withdraw this application and to file again. So there is considered an error.
Lordship, one more prayer. I may be allowed to have the impugned order, certified copy of the impugned order which is filed in it.
There is considered and allowed. Matters are dismissed on withdrawal. Liberty to file again. Next one. The young counsel for the petitioner is permitted to correct the certified copy of the order dated 24/2/2026. By providing a photocopy thereof to the registry
The
for being
annexure is
made a
already.
part of record. Okay, just give a photocopy and then take that.
Okay.
For motion, item 3.
Please, my lord, the petitioner, my lord, she is the wife, my lord. The marriage took place in Gauhati in the year 2014, and two children were born, one girl and the other the boy. My lord, because of the atrocities committed by the respondent, she had to file a domestic violence case. And I have annexed the copy of the order. And in the meantime, the respondent has filed a divorce petition before the court at Nalbari. The next date is fixed on 12th of June. It is evident from page 26, my lord. So, and if the pleadings of the divorce case is seen, there's no grounds as regards that a cause of action arose in Nalbari. So, in that view of the matter, and both the petitioner and the respondent, they are working in Gauhati, my lord. The petitioner, she is
No.
working.
Your statement somewhere is that he is working as a DFO in Meghalaya.
No. They have an office in Bokisto,
I
Meghalaya
don't know, but
department.
you have made some statement somewhere.
I made a statement that he is working in the Bokisto.
Okay. Third instance, counsel for the petitioner
Para 20, madam.
by his application under section 24 of the CPC, the petitioner is the estranged wife of the respondent is seeking transfer of matrimonial proceedings being matrimonial suit number 96 of 2026 from the Court of Learned Principal Judge, Family Court, Nalbari, to the Court of Learned Family Court at Kamrup Metro, Gauhati. Next, it is submitted that the petitioner is taking care of two minor children of the parties and the respondent is also participating in domestic violence case filed by the petitioner against the respondent, which is presently pending before the court of
The domestic violence court is a judicial magistrate FC number 3, Kamrup Metro.
judicial magistrate
Number 3.
number 3, Kamrup Metro, Gauhati. That's right. Issue notice returnable. So and so. Petition shall take steps within 2 days for service of notice on the respondent by speed post to the AD. Then counsel for the petitioner is permitted to collect the postal receipt number and submit postal track report prior to the next date of listing. Next, as an interim measure, until the next returnable date, the further proceedings of matrimonial suit number 96 of 2026 pending before the learned principal judge, Family Court, Nalbari, shall remain stayed. The petitioner shall cause production of a certified copy of the order before the said learned court to make the order effective. List of so. You produce certified copy of the order. Item 4.
Met legal lordship. Petition before lordship, application 24 the CPC, while the proceeding is pending before the principal judge, Family Court, Gauhati, and pending before the district and session judge, Biswanath, my lord.
On what ground?
Ground basically, my lord, petitioner is working as a assistant professor, Dindayal Mahavidyalaya, my lord, at Jinjia, Biswanath, and respondent also working at Nagaon College, my lord. And my lord, the divorce petition is filed before the Kamrup Metro, or Kamrup, my lord. Only sole ground is that the marriage was solemnized at Pay School, and she is working at Biswanath, my lord, Jinjia, my lord. And other ground is that, my lord, there is a section 13 of the Family Court Act, my lord. But is not allowed to the council advocate, my lord, in Gauhati. And they through the proceeding, she cannot be, my lord, informed Biswanath. And she is the only daughter of the parents, old as a parent with ailments in parents' day school. So he is working in Nagaon and petitioner working in Jinja. So the best place is Biswanath, my lord. I may allow to, my lord.
No, sir. Only the definition number. Mr. N. Bora, learned counsel for the petitioner. Transfer of FC civil case number 478 of 2026, which is filed under section 13 within bracket numerical 1 within bracket I dash A bracket close and 13 within bracket numerical 1 and again bracket numerical I dash D because of the Hindu Marriage Act read with section 27 1B and 27 1D of the Special Marriage Act from the Court of Principal Judge, Family Court 1, Kamrup Metro Gauhati, the Court of Learned District Judge and Vishwanath. Page 1. Huh? That could be. Learned counsel for the petitioner has submitted that the petitioner is a resident of Nova. The marriage was solemnized at, sorry, Tejpur, and solemnized at Tejpur. And the respondent, who is the estranged husband, is also working at Nogao. It is also submitted that the petitioner is the petitioner, being the only daughter of her aged parents, is looking after them. Next part. When you refer to aged people and give their age as 58, I would be senior to them.
Mother, my lord.
No, whatever be, but you say aged. 58 would not be an aged, should not be a.
It is working, not working with a housewife, my lord, and other hand, my lord, some sleep, this are there, my lord. Ailments.
Don't say that, aged people. The parents will be protected, suffering from ailments, and she's taking care of them. Next, issue notice, same order, stay, and you'll have to produce the certified copy of.
My lord, this order.
Much obliged.
Issue notice register post.
2 days. That's
Item 5.
Item 5.
May I please, ma'am? My lord, this petition I may be allowed to withdraw with liberty to file under the appropriate provisions of law, ma'am. My lord.
I heard Mr. A.K. Gupta and counsel for the petitioner and Mr. Anand Datta and counsel for the respondent. Next paragraph. Referring to the order dated 29/5/2026, the learned counsel for the petitioner has submitted that he has instructions for the petition and to approach the court in an appropriate jurisdiction.
No, my lord, under the appropriate provisions, because this is filed under 115 of CPC.
Appropriate jurisdiction, I'm saying.
No.
First off. Next, considering this such prayer, the prayer is allowed, the matter is dismissed from withdrawal with liberty as paid for.
Obliged.
Jurisdiction would include both provision of law as well as the court.
My lord, right.
Wherever you want to go.
Obliged.
Item 6.
May please your lordship. Your lordship, we are moving the civil revision petition number 76 of 2026 along with its accompanying stay application, that is IA civil number 1815026. Your lordship, this revision challenged the final impugned order dated 22/5/2026 passed by the learned civil judge, New Division number 2, Shunitpur at Tezpur, in Miss J case number 23/26 in connection with title suit number 95/2018. Your lordship, the impugned order is annexed as Annexure 7 at page number 87 to 95. May I, lordship, may I read the impugned order?
No, don't need such a big order. Just tell us what is there.
Yes, So Lordship, by this order, the learned trial court dismiss our application file under order 23 rule 3 read with section 151 of CPC to recall and set aside an unexecutable and unlawful compromise degree passed by the same
Once
trial
it is a
court.
compromise degree, is a compromise degree, whether lawful or unlawful, will be why will the court go into it? If it is inexecutable,
Yes, Your Honor.
then we can't do anything. It's your agreement.
Lordship, this
The compromise decree
Yes.
was passed in on 22/12/23.
Yes,
Now you filed the miss case in 2026 after 3 years.
Your Lordship, subsequently, after the pass of the compromise degree, there is a adjudication proceeding was filed by the parties, Your Honor. Sorry, Your Lordship. Your Lordship, we have
Where is the compromise agreement and degree? Which page is your compromise agreement?
compromise, Your Lordship, Annexer 1B, page number 21 to 24.
Where is your petition? Where is your compromise petition?
Compromise petition, Lordship, Annexer 1C, page number 25 to 30.
What is the illegal part in this compromise agreement?
Your Lordship, clause B, the land was 2 bigger 3 kata 4 lesser total land, Your Honor, Your Lordship. In the subsequent warrant issued by the learned trial court, the Nazif with the concerned Lat Mandal found that the land was not found in the ground, Your Lordship. Your Lordship, Annexer 3B Coli is the field report, Your Honor, Your Lordship, submitted by Arnett Nazib. Page number 43 to 15. Your Lordship, according to the Nazib report, there is a shortage of land. Your Lordship, the learned Nazir also deposed on oath before the trial court that the land measurement 2 giga for 3 kata 4 or lesser was not found in the ground when they visit the land.
But you see, you have entered into the compromise degree with eyes wide open.
Yes, Your Lordship.
The Transfer of Property Act says that the party will deem to have notice of
Your Lordship.
all facts. Thirdly, the agreement which you have entered was a part of the compromise,
Yes, sir.
and caveat emptor was applied that you know the facts and therefore you have entered into a compromise. The The surname of both of them are same.
Yes,
They are
Lordship.
brothers.
Yes, they are family related, Your Lordship. Your Lordship, under section 20 of the Indian Contract Act, it provides, Your Lordship,
This is no longer a contract. Where the agreement is has the same effect as error of law.
Your Lordship, before entering the compromise petition, we do not know about the shortage of your land.
So, but without measurement, you see, you enter into an agreement. How would be bad?
Your Lordship,
So let
according,
us say that you enter into an agreement for a shop in a premises. And then you find out that this shop is not the property of the person who has bought it. What would be your remedy? It was only for a return of money.
Your
It was only
Lordship,
for return of money. Here you will have no
Your
remedy at all.
Your Lordship, the clause B of the compromise degree, that is DAG number 386 of under POD pattern number 78, was totally on the position of the respondent, Your Lordship. And they promised to hand over our portion. And then we will hand over the portion that was on our position, Lordship. Your Lordship, if this degree is executed, then our rights that we expect to get will not deliver to us. Due to the due to the shortage of the shortage of land, Your Lordship.
But we have committed blunder in this agreement. You can't do anything. Your agreement binds yourself. You see, you have given the clause at page 27. The plaintiff shall withdraw title suit number 32 of 2019 pending in the Court of Civil Judge Unit Division 1, Tejpur. They shall not claim any right, title, interest, and possession on the suit land of the said suit. You arrive at an agreement. Land will be partitioned, but in the agreement you say that you will not claim any right, title, interest, and possession.
So, Lordship, clause B is specifically disputed now.
D, C, D, but you see, everything has to be read together in an agreement. You can't read in isolation.
Yes, Lordship, we have tried our best to the execution of the degree, but your Lordship, in the subsequent survey, it is found that as per term B of the compromise degree, that the total measurement 2 bigger 3 kata 4 lesser land was not found, which is supposed to be found, your Lordship. And we expected that we will get our
No,
share.
that is also not very clear. You see, if there's a land in the Jamabandi,
Yes,
the land will always be there. It may be the part of the land may not be in the possession of the plaintiff. The land will not get lost unless it is taken away by river erosion. The Jamabandi shows according to you, the Jamabandi shows 2 bigha 4 lesha.
yes, Lordship.
So where is that 2 bigha 4 lesha? The Nazi report does not say that the bag does not contain 2 bigha 4 lesha.
Your Lordship, as per compromise petition.
So therefore, this land has to be in the possession of somebody else.
Yes,
Somebody is encroaching that part of the land, and you have entered your eyes open. You have entered into that agreement.
no, your Lordship, concerned Lat Mondal, Annexer 3B Poly, your Lordship, is number 44. Is the typed and selected copy of report submitted by the concerned Lat Mondal, your Lordship. Your Lordship, it is reported by the learned Lat Mondal that on 6/1/2025, in pursuance of order of the Honorable Court in Title Execution number 20/2020, the lands under DAG number 125 of periodic Patta 87, DAG number 386 of periodic Patta number 78, and DAG.
You see in page 44, what the Lat Mandal says. At the site, the decree holder, the co-decree holders, and the concerned Lat Mandal were present.
Yes.
However, after identification of the scheduled land, the concerned Lat Mandal could not hand over the scheduled land.
Yes, your Lordship.
That does not mean that the land is not there. The Lat Mandal says, I cannot hand over the land.
Yes, Lordship. subsequently, there was a deposition of Nazir on oath. Your Lordship, annexer annexer four, annexer 4D, Your Lordship, page number 56.
50,
56,
50,
56.
56.
Your Lordship, Your Lordship, here is stated that that
Okay, your name?
Your Lordship, King Shah, K. Shah.
What is the case, Sahar, and counsel for the petitioner? Next. Filing this. Application is section 115 of the CPC. You'll have to elect one. You are filing this under 115 and 227. You have to make a choice. This will be under 227 or 115.
227.
This is an application under section 115 of the CPC read with article 227 of the Constitution of India. This has both separate jurisdictions from the learned counsel for the on a query of the court from the learned counsel for the petitioner states that this petition be treated as one under article 227 of the Constitution of India. Accordingly, the registry shall strike out the provision of section 115 of the CPC from the cause title of this application. Which is at page 1 of the application. So accordingly, this application shall be treated as one under article 227 of the Constitution of India. Next, by filing this application under article 227 of the Constitution of India, the petitioner, who is the judgment debtor in the compromise decree dated 22/12/2023, passed by the learned Munsif number 2, Tejpur, in DS 95 of 2018, have assailed the order dated 22/5/2026, passed by the said learned court, refusing to set aside the compromise decree Next paragraph. The learned counsel for the petitioner has submitted that although a compromise agreement was entered into between the petitioners as judgment debtors and the respondent as decree holders, but the time of execution, it came to the Lat Mandal and the Nazir who had gone for execution of the decree found out that the land covered by DAG number 386 of PP number 78 of village Gotlong, GOTLONG, did not have land measuring 2 bighas 3 kata 4 lecha, and therefore the decree could not be executed. This topic is submitted that as the compromise agreement was made on the basis of error of fact, Section 21 of the Contract Act would be applicable, which would entitle the petitioner to sell the compromise decree. Next one. Issue notice returnable on so and so. Petition shall take steps within 2 days for service of notice on the respondents by speed post PDD. List on
24th of July. Okay. So Lord, Lordship.
IFO.
Here, stay for the all further proceeding of title.
If the land cannot be handed over, what would execution do?
Your Lordship, the learned trial court or being the executing court, revive the companion file of title execution case number 20 of the
What would happen? You want to get the land.
Yes, Lordship.
You say that it is not being executed. Then what would happen in the
No,
case?
Your Lordship, the respondent already filed an execution
For what?
for execution of 390, Your Lordship.
If I pay your lordship.
No, let me speak. Two people can't, I will make some meeting.
Your Lordship, respondent already filed an execution
For what?
for execution of 390, for execution of the compromise decree, Your Honor. Your Lordship.
You said it's not executable, and then you said you are.
Your Lordship, they have already filed the execution proceeding.
That I have understood. There's no need to tell us for 3 times that same thing. But the execution is for what?
Execution is for the execution of the compromise degree.
If it is executable, then execute it. Why you are here challenging that order?
Your Lordship, or the learned trial court already issued a warrant, delivery warrant, fixed for 5/6/2026.
Then you are getting your land. The land is not available. Then you are getting your land if the warrant is there.
Yes. Your Lordship, 386, under tab number 386, the land is not available, Your Lordship.
Yes.
If Your Lordship, if a forceful execution is allowed to proceed before this honorable court and can execute our present petition, it will cause an irreparable loss.
You tell us where is the application for execution? Where is that?
Your Lordship, Annexer 8, page number 96. Page number 96. 96, Your Lordship.
No, where is the application for execution? What is, then doesn't help us.
Your Lordship, Annex A, Your Lordship, Annex 2A and 2B. Page number
Page number,
31
give
and
us page number, don't tell us the next number.
Your Lordship, 36. Page number
36.
36.
Okay, in the IA you say, heard so and so, you should notice on this, the application for stay of the execution of the compromise decree dated
Dated Your Lordship, 22 12 2023.
20,
22 12 2023. Lordship.
22/12/2023,
Your Lordship.
passed in TS 95 of 2018. So it is stated that as per the joint compromise decree, the petitioner's side was entitled to share in land covered by doc number 386, and the respondents were entitled to land under doc number 370. Where is that order you said? You were referring to the order right now? Which order?
Decree order. Your Lordship, Annex, page number 18, Your Lordship. Page number 18 to 20.
You are the counterclaimant.
Yes, yes, Lordship.
Interesting, when you made us read this. In the suit, there was a counterclaim,
Yes, Your Lordship.
and the compromise was in respect of the suit. What happened to the counterclaim? There is no compromise for the counterclaim. The counterclaim was not closed by the compromise decree.
Yes.
Then why are you not pursuing a counterclaim? There was a compromise for the suit, not in the counterclaim. It does not mention that with this, the suit and the counterclaim will both be closed. Why are you here then?
Your Lordship, both the matters settle in one compromise decision, Lordship.
Does that order say about compromising the counterclaim? Better take some advice from somebody who can deal with these issues. I don't think it is an appropriate case to interfere at all.
Your Lordship,
You take it up day after tomorrow. Be prepared. There's no decree for the closure of counterclaim. You take it up day after tomorrow. Be prepared.
tomorrow,
And difficulty.
Your Lordship, the delivery warrant already issued, Your Honor, and
No, but please tell us.
Your Lordship,
Your main grievance is against the compromise decree.
yes, Lordship.
If the compromise decree itself does not create a bar against your of your adjudication of the counterclaim, how would this be maintainable? Why we should grant a stay? You tell us if there is a flaw in the reasoning. You tell us if there is a flaw in the reasoning. There is no decree for counterclaim to be closed.
Your Lordship, can I help my colleague? He is also.
Yes.
He is also filing advocate.
Can it be fixed tomorrow, Lordship, because
Tomorrow.
Lordship.
Okay. Don't say the prayer made by the counsel for the petitioner based on.
And Lordship,
For-
the execution proceeding is also in final stage on 5th of this month.
You satisfy us, you see, we are giving you an opportunity, we are not saying that we will not hear you. But we are asking you a question.
Okay,
If
Lordship,
there
we'll
is
try
no
to
compromise
satisfy Lordship.
for the counterclaim, what prevents you from proceeding with the counterclaim? And if that order does not come in between, you get the liberty and proceed with the counterclaim, but there is no challenge to the execution of the decree. So how can that if the decree is not under challenge, how can we stay that?
We'll try to satisfy Lordship tomorrow.
Item 7.
Obliged.
Item 7.
May it please, Your Lordship, I'm aggrieved by the order passed by the special tribunal land grading Sibsagar, Your Lordship, page 46, Your Lordship, may kindly peruse the order. The special tribunal, Your Lordship, page 46, has declared the right, title, and interest of the scheduled land. May I read the order, Your Lordship? Yes, page
46.
46, Your Lordship. The land giving proceeding took place, and this was the order. The right, title, and interest was decided.
Who is the complainant in the land grabbing case? Who are the complainants in the land grabbing case?
The complainant, Your Lordship, or the respondent in this case, Your Lordship.
Respondent is the complainant.
Respondent.
Okay.
Midula Gogoi, the respondent number one, the only respondent.
Okay.
Page 46, may I read your lordship?
And where is the initial report by the circle officer? What do you call, pre-litigation report?
I have not annexed it, your lordship. The pre-litigation report is not annexed, your lordship. The complaint is at page 19, your lordship. Starts from page 20. May I read, your lordship?
Yes.
The complaint is a teacher representation on 15/12/2006. The complainant lawfully purchased the land described in the schedule.
No, what is the finding of the teacher agree? Don't read this long order.
Oh. The finding, your lordship, is find in page 50. On the 46 is the 46 is
The
our.
tribunal held you to be a land grabber.
Yes, your lordship.
The tribunal accepted the plea
Yes,
of
your
the
lordship.
respondent
Page 54, your lordship.
that they have purchased the land, and on a particular day in 2019, you took over the illegal possession of the land.
Yes, your lordship.
That was accepted.
Yes, your lordship. The she purchased a plot of 1 katha land, your lordship. Subsequently, in the year 2018, it was converted to 1 katha 4 lecture, your lordship. Your lordship, may kindly peruse page 54 of the order.
You said that there was a deed of rectification.
Yes, your lordship. In the year
But
2018.
who is the vendor? The vendor,
The respondent number 1, your lordship.
respondent number 1 is the vendor.
Yes, your lordship.
You purchased the land from the from respondent number 1.
We did not purchase the land, your lordship.
Then-
We are inherited the land, your lordship, and we are, according to us, we had not grabbed the land, your lordship. Your lordship, may kindly for a moment, if your lordship may kindly peruse
You
page.
see, the case of the respondent is that she had purchased 1 katha 4 acres of land,
Yes, your lordship.
and after purchasing took over possession.
Yes, your lordship.
Now, on fact, that part of the purchase of the land could not be demolished.
Your lordship, may kindly peruse page 32 for a moment.
32.
32, paragraph 10, your lordship. Paragraph 10.
Yes.
That for thus disposal of the case at hand, this answering accused beg to state the following facts as under. That Khoghendra Singh, since this is father-in-law and grandfather of the accused number 1 and 2 to 4, respectively, was the settlement holder of the entire land measuring 1 bigha 4 katha 2 lesser, is covered by Dagi number 563 of Patta number 220 of Schedule Moja Gaon and Revenue Circle. Of the said 1 bigha 4 katha 2 lesser of said land, Khoghendra Singh sold 2 katha 515 lesser of land to 2 persons, with Mohendra Guha and Sri Gulab Soikia jointly during his lifetime, retaining keeping 1 bigha 1 katha 7 lesser at his hands. After the death of Sri Khoghendra Singh, his 3 sons again sold 2 katha of land out of 1 bigha 1 katha 2 lesser to 2 persons, with Bhulanath Gogoi and Sri Numal Chandra Kumar. After such sale, the legal heirs of said Khoghendra Singh retained 4 katha 7 lesser of land jointly. At the time of the above said reflection, the accused number 2 to 5 were minors, and their grandfather Gauhati Singh also died in the meantime, and as such they had no knowledge about the same. While they attained majority, they found a portion of land more or less 1 katha of the PP number 220 is lying vacant instead of 4 katha 7 lesser, and to their find out their actual land, the accused along with their brother-in-law and uncle instead a title suit. Now there is a title suit pending, your lordship. Title suit number 19 of 2018 in the court of the civil judge Shivsagar against Sri Bhula Goi, legal heirs of Simanta Goi and Sri Durga Goi for recovery of their land. In the above suit, Bhula Goi and Durga Goi appeared and filed their written statement. After going through the contents of the said written statement, these answering accused came to know that the father and father-in-law, grandfather of legal heirs of Sri late Simanta Goi late Bhagavat, that is, the late Bhogadhar Goi also purchased 1 kata of land from the father-in-law, grandfather of this answering accused. Bhagendra Singh by way of registered sale. The above fact was not known to them as because they were minors and also the purchasers did not get their name written in the revenue record. Thus, this answering accused along with their uncle ought to have 3 kata 7 letters of land, but in fact they are possessing more or less 1 kata of land of the said Pata and Dag as referred to in above. But that is why we have filed a suit, Your Lordship. The suit is pending, Your Lordship. If respondent number
But that-
1 was not made a party in that suit, I agree.
But
with
that
Your
suit
Lordship.
is not against the
No,
respondent
not
number
against,
one.
not against.
And number two, you have also not demonstrated here as to why you should file a case against this Bhulanath Gogoi. For that, you'll have to show that he is one of the co-patadar.
The
And
party
in
suit
this-
is pending, Your Lordship.
No, that's okay.
Yes, sir.
But in order to assert the title with respect to the same land,
Yes, Your Lordship.
you should have demonstrated before the land grabbing tribunal that the identity of the land, which is the subject matter of your TS 19 or 18,
Yes, sir.
is same as the disputed land in the land grabbing case. You don't
We
find
did, Your
anything
Lordship.
here.
We did state that, Your Lordship. We did state that, Your Lordship,
Hmm?
but the court did not agree, Your Lordship. The land grabbing tribunal did not agree. Your
Where is that finding? I have missed it
Lordship.
there.
Your Lordship, page 54
54.
of the order, Your Lordship.
Yes.
Paragraph 15, the applicant complains in the middle ago in support of her case submitted evidence on affidavit of herself as PW1 and reiterated the facts which has stated in her application complaint. PW1 in her evidence stated that in the scheduled person the registered sale deed executed on 15/12/2006, the area of land was mentioned as 1 kata in place of 1 kata 4 lesser, and as such a rectification deed was later executed by rectification deed number 245/2018 dated 38/2018 for correction of schedule from 1 kata to 1 kata 4 lesser. PW1 executed both the original sale deed dated 15/12/2006 and rectified sale deed dated 38/2018 as Exhibit 1 and Exhibit 2 respectively. Now, Your Lordship, paragraph number 16, last 4 line, Your Lordship, may kindly see. There was a CW1, Lat Mandal, Your Lordship, paragraph 16.
Yes.
Yeah, 5th line, Your Lordship, from bottom, code number 1. CW1, Your Lordship, the court witness number 1, the Lat Mandal in his evidence reported on 2012-2020, he was working as Lat Mandal at Sonari Revenue Circle and that he has submitted a report wherein he stated a disputed land of PP number so-and-so compared to Dag number so-and-so, having an area of so-and-so land of Gorkhala Boragaon, having the following boundary of his North Milan Bhuya, South Dhudar Ali, East Sanjeev Kumar De, East West Arjun Buragha and Dibya Buragha is in possession of Basanti Devi, Gautam Singh, Vasudev Singh and Prabhat Singh and Prashant Singh. Since last 3 years and they have set up a bamboo fencing around the plot of land which is lying unutilized. CW1 further deposed that as the opposite person in possession of the disputed land, the applicant could not mutate her name for the said land. Now this CW1, Your Lordship, in his cross-examination,
Where is your plane? Do you have a copy of your plane?
Page 37, Your Lordship.
35.
That's page 37, the link, Your Lordship.
So 35 is not your plaint, it is your objection.
No, 37, Your Lordship. It starts at 37, the plain starts at 37, Your Lordship.
You see, in your plaint, you admit Bhavendra Singh to be the owner of the land in the lifetime. He sold the land to the respondent.
Yes, sir.
That sale is also admitted.
Sale is admitted, Your Lordship.
If sale is admitted, where is that land first?
No, Your Lordship, the sale is admitted, but the land that she is claiming that it belongs to her, we have grabbed it, is not right, Your Lordship. The suit is already pending to decide the issue as to whether that particular.
No, that is not with her. You have not even implicated the legal heads of the what do you call, the vendors. Vendor is your own uncle, I think. Bhavendra Singh is who is Bhavendra Singh?
Bhavendra Singh.
Bhavendra Singh would be your uncle.
No, Bhavendra Singh is my grandfather, Your Lordship.
Grandfather. Huh?
Grandfather.
So that means you become the legatee of that sale.
Yes. No, Your Lordship. This particular respondent.
Sells an estate.
Yes, Your Lordship.
You became the legatee to that sale. You can't disown that sale.
No,
by your grandfather.
Yes, sir. I'm not disowning it, Your Lordship.
Yeah.
The only fact, Your Lordship, is that in this case, this particular respondent, she has not purchased the land from us. She has purchased it from somebody else. So not from us, Your Lordship. She has not purchased the land from us. She has purchased the land from
You see, you admit that during his lifetime he sold 2 kathas, 15 lachas of land. Out of 1 bigha, 4 katha, 2 lacha. To 2 persons, that is Mohinder Bhai and Gulab Sekia.
Gulab Sekia.
And in this, in their complaint,
Now,
page 33, it says that the land was sold to Mohinder Bhai and Gulab Sekia. And therefore, he says that she has purchased the land from
she has purchased the land from us. Mohinder
Bhai.
Bhai.
She has purchased the title.
Yes, sir.
And if you are in that land,
No,
the
my
landowner gives a report,
Yes, sir.
then you will have to suffer the consequences.
No, my first grievance, Your Lordship, is that whether the court can declare right title interest under the Assam Land Grabbing Act, Your Lordship, may kindly raise the judgment, Your Lordship, of this honorable court. Your Lordship.
That would be wrong, but doesn't matter. The essential part is to be put into possession of the land. Even if that order is wrong, there is a full-blown decision on it.
Yes, sir.
The right of interest cannot be declared.
Yes, sir.
So only that part would become wrong, but the delivery of possession would still be maintainable.
And the Monroe report, Your Lordship, the last Monroe report, the court witness number 1, Your Lordship, he had not done physical verification of the land, Your Lordship. He has merely given the report. That is not in the order, Your Lordship, but the.
No, you see, under under section 8, the lot vendor will have to give a report first based on that, the land grabbing cases are registered and then executed. There's an initial report that is pre-cognizance report. I asked you the first question.
No, yes, Your Lordship, I understand. But in this case, the Latmondal, who was made a court witness, Your Lordship, he had given a report. If Your Lordship may kindly peruse the other cross-examination, Your Lordship. I'm extremely sorry, I'm not annexed it, Your Lordship.
Is there at page 56? There's a discussion on that. I have perused the cross-examination of the aforesaid witness, including CW1. The execution of the rectification is not in dispute.
But he has, in his cross-examination, stated that I submitted my report as per official record and I did not physically measure the land as the said land was underwater. This was his in the cross-examination. The last member has very categorically stated.
No, but you did not dispute it. You did not lead your own evidence for that you are not a land grabber.
I have, Your Lordship. I have given my statement DW1 and DW2, Your Lordship. You have given, that was not considered, Your Lordship, kindly.
No, because yours is a oral evidence alone.
Yes, Your
When you don't dispute the sale, you will have purchased the land at some place in the same tract, which is the same tract which covers 1 giga 4 kata 2 acres of land. You don't deny the sale, you don't also deny the
The sale is with respect to 1 katha of land, Your Lordship. The rectification deed has been done after 12 years, Your Lordship, and that is for 1 katha 4 lesser. After 12 years, there's no reason recorded, Your Lordship. 15/12/2006, the sale deed was concluded for 1 katha of land. Then after 12 years, Your Lordship, it is 1 katha 14 lesser.
Will it be
Rectification
illegal?
deed, 2018.
Will it be illegal? It will not be illegal.
No, Your Lordship, I'm just saying 1
Then-
katha. There has to be some record. We have not made any record, Your Lordship. There's no record to corroborate the fact in my triple submission, Your Lordship. There has to be some record in my triple submission, Your Lordship, to corroborate the fact.
That is the agreement between the parties.
Yes, Your Lordship.
If the vendor is agreeable to sell further 4 acres of land, what is wrong in it? There is no criminal liability imposed on you. So if you have, you can impede those and pursue the suit. The right title interest will be, only that part will be interfered with. Third, let's see the original counsel for the petitioner. Petitioners. Next paragraph. By filing this application under section 115, Article 227 of the Constitution of India, the petitioners were the respondents in the proceedings of special within bracket LG bracket was case number 1 of 2019. Still the impugned judgment and order dated 24/3/2026 passed by the learned additional district learned additional sessions district and session judge, FTC, presiding officer, special tribunal within bracket land grabbing bracket was Sivsagar. So by the said order, confirm the learned special tribunal had declared the right title interest in favor of the respondent, but also issued a direction to the a direction for putting the respondent to possession of the land through process of the court. Next paragraph. The learned counsel for the petitioners has submitted that the special tribunal within bracket land grabbing is not empowered to grant a declaratory relief in favor of the respondent. Therefore, permitted that the said judgment and order is not sustainable on facts and in law. Next paragraph. If you notice, returnable on so and so, petitioners shall take steps within 2 days for service of notice on the respondent by speed post with AD. Next paragraph. Having regard to the nature of pleadings and evidence on record, or the court is of the considered opinion that there is a specific finding by the commissioner that is recorded in the interim order that the disputed area has a land covering 1 biga, 0 biga, 1 kattha, 4 lecha with definite boundaries as mentioned in paragraph 7 of the interim judgment and order, and clearly stating that for the last 3 years, the petitioners have set up a bamboo fencing around the plot of land which is lying unutilized. Having noticed that the respondent has been able to demonstrate the entitlement to possession, while not interfering with the order insofar as it relates to putting the respondent into possession. But as the learned special tribunal within bracket land grabbing bracket to Sivsagar has also declared the right title in interest of the respondent over the scheduled land, court is inclined to state that part of the interim order, judgment and order dated 24/3/2026, passed by the London Special within bracket LG Tribunal, Sivsagar, in special within bracket LG case number 1 of 2019. Next paragraph. List on so and so. So that part is stayed. The exception is I am not west of staying.
Till the next day, your lordship, otherwise the entire thing will become successful.
No.
Till the next day, your lordship, I'm only praying
No,
for the
no, no.
execution till the next day.
Because she has shown the position. She's been able to demonstrate her position, the entitlement to position.
But if your lordship kindly peruse the other witnesses, your lordship, the statements of the witnesses, it is not, she's been able to establish.
You see, there's a commission report. That commission report has not been challenged. The finding is to the effect that she's entitled to that land. In Land Grabbing Act, if we stay the proceedings, there's people will start getting land.
In this case, Your Lordship, special submission, we have not grabbed the land, Your Lordship. We are basically all land grabbed, Your Lordship. We do not know. That is why we have filed a suit.
You see, if there is a land which is sold by your grandfather,
Yes, sir.
and for the vendor of the grandfather he has purchased, because that the transaction was illegal, that's not. And having the sale deed, one would also be entitled to possession. The fact that she took possession is not also disputed.
But the sale deed was with respect to only one katha of land, Your Lordship. The rectification deed was done after 12 years for one katha.
That has to be a
That
sale.
has to be, yes, Your Lordship.
That has to be a sale. You do it in an appropriate manner.
But if
You
this
see,
order-
land grabbing case does not create the bar of res judicata.
No, Your Lordship. That's it.
So you can still file a suit and then you can have it annulled. Position we are not trying to interfere right now. Yes. Take a short break and come back.
I'm very good for that.
Item 9.
But my cross-examination and evidence was expunged, my lord. I have annexed the order sheet, my lord. Before the commissioner, I took court adjournment. Actually, I was absent for fourth time. And on that day, this order has been passed. Not adjournment, I was absent.
Here, the petitioner has assailed the order dated 18/3/2026, passed by the learned civil judge within bracket senior division, bracket Dhubri, in PS 31 of 2020, in which the cross-examination of DW1 was closed. Next, by filing an additional affidavit, I first submitted that
And evidence was also this.
Huh?
Evidence on
was
affidavit.
expunged. Was closed, cross-examination closed, and the evidence was expunged. Next, by referring to the additional affidavit filed pursuant to order dated 27/5/2026, committee submitted that the cross-examination was to be conducted by the commissioner, but on 4 dates which were fixed, the petitioner was absent. First of the learned counsel for the petitioner submitted that there was some family problem for which the petitioner as DW1 could not appear for his cross-examination. Next paragraph. Issue notice returnable on so and so. The petitioner shall take step within 2 days for service of notice on the respondents by speed post with AD. Next paragraph. As in, the learned counsel for the petitioner is at liberty to collect the postal receipt number and submit postal fact report prior to the next date of listing. Next paragraph. As an interim measure until the next returnable date, the further proceedings of ES number 31 of 2020 or pending before the Court of Learned Civil Judge within bracket senior division, that Dhubri, shall remain state. And is for the petitioner shall cause production of a certified copy of the order before the learned court.
Item 12.
So,
Ma'am, please allow us.
Number
Yes.
12, no, but
Yes.
my lord, here is the case, my lord. The plaintiff filed a title suit. We have filed our WS cum counterclaim. Three evidence have been examined and cross-examined. Without any due diligence, my lord, and commencement of the trial, filed their amendment petition, my lord. And that amendment petition, they filed the title suit relying on the list of documents, particularly the sale deed matter. And that case was filed May 2007, relying on the 2017, sorry, my lord. Relying on that, my lord, they have filed the title suit. Evidence also they have adduced. List of document, everything has been
Where is
adduced.
the
my lord.
interim order?
Impin order, lordship will see at page 263, my lord. May I read, my lord? Lordship. Impin order. Give it to tomorrow.
So they are only adding village number 3.
My lord, the case will go, everything will change, man. The moment, because lordship also.
No, no, no. Even I have passed a lot of orders where I have said that even in the execution stage, the description, misdescription of the property can be cured.
My lord,
And I have, in this regard, I have followed the judgment of the Supreme Court of India.
yes, my lord, there I brought it, my lord. There, my lord.
Under Order
two-
7 Rule 3, a misdescription.
Yes, my lord, two things
And
is
this is not a
needed.
misdescription. They said that the original land was in village Kailipara.
Kailipara.
And now it is number 3 Kailipara.
No, my lord. Now, my lord, according to them, my lord, they have relied three documents, my lord. Sometimes, in number Kailipara 1, Kailipara 2, Kailipara 3, my lord. Lordship kindly take out page 90, my lord.
90.
90. Their document, my vernacular part, my lord, act number Kailipara.
92.
90.
Yes.
Lordship has passed two line manner Beltala Mojar Act number Kahilipara. That is their mutation. Now Lordship kindly turn to page 92, extreme top.
Now it is 3.
Now it is 3. Again it will come, my lord. Then Lordship will say,
Are you wanting to say that the respondent, every time this suit is going on, he influences the state revenue authorities and keeps on changing the name of the village number?
no, my lord, they
He
never.
is not the author of that document.
Yes, he is not.
He gets a document that in the chitta it says village number 1.
Chitta, it was there in 2017, my.
That's okay. He writes a particular document. He has a document which says it is number 1. He files that suit in according to that. Now the documents are that it is.
My lord, what will happen to his sale deed? Sale deed says about everything will change now.
No. That will not. That will not.
Lordship kindly see their land, my lord, page 88, operative part of the sale date, my lord.
Have you seen that? For that, he will do whatever he wants. But in the suit, it is the number 3, and that is supported by draft chita.
Draft Chita, my lord, due diligence, question will, due diligence will come. They have filed suit
You see,
17.
I understand, due diligence. Now, please tell me, you have a land somewhere in the earth?
Yes, yes.
Yes, you have some land somewhere. Do you every 15 days, 20 days, or 1 month, 3 months, or 1 year, go to the settlement office to check up the number of the village?
I never go,
Not required.
not at all.
So then for him, why
No,
is
my
it
lord,
required?
my only question before lordship is that, my lord. Trial has commenced. And
Oh,
judgment,
that is permissible even in exhibition.
yes, lordship, there is some due diligence has to be there. Now,
What is
question
due
will,
diligence according to you?
my lord. Diligence, my lord, they filed the list of documents, they filed everything, evidence, cross-examine. The moment cross has been done, 2 officials, now they came for amendment. That will be prejudice to me, my lord.
No, no.
All my defense has been out. I
No,
have
no.
already examined, cross-examined 3 persons. 2 settlement
You
office.
can ask the re-examination if you want, but the misdescription of the land.
And nowhere in the petition, my lord, they have stated, my lord, when they have seen, when they have, it is not there,
That
just
is not even required. When this court has permitted even in exhibition case, misdescription.
my lord, there is, correct, lordship is correct, my lord. If it is, my lord, due diligence, then it will all right. But here, my lord,
But they are asking you, according to you, what is the meaning of due diligence?
due diligence, my lord, there is interpretation of, my lord, it was a to judgment, I have relied, my lord. I'll supply your lordship, my lord. It to disseminate. But mat kara hota, more office copy diye.
Lordship, Lordship, my senior has been engaged in this case today morning itself. We will be filing the wakalatnama today. So this case may be fixed on Friday. We can be.
Okay.
For this due diligence. Good.
Mr. Jaya Bhogner and counsel of the petitioner is present.
I did not.
S. Faridi.
F for it.
F. Faridi, learned counsel. Submits that he has received instructions to appear for the respondent and is filing his wakalatnama in course of the day. He prays that the
What do you tell me?
matter be taken up
Defined in the sufficiency. Like with the Oxford inversion.
on fifth by which the
And
fifth.
persisting application or effect. Diligence means
Matter stands adjourned today. The learned counsel for the petitioner shall provide a copy of the
copy to patient.
revision application to the learned counsel appearing for the respondent in course of the day. List on 5/6/2026.
But instead of Friday, my lord, can it be on Monday?
Monday, 8/6/2026.
So for due diligence, my lord, SCC 2000.
We'll take it on that day, we'll hear you.
But
21.
একটা copy দিয়ে দিবা, হ্যাঁ? তার phone number তো লো।
Case lordship, I am from the respondent number 1 to 4. Format is there, but
Just a moment. Yes,
and for respondent number 1 to 4, lordship. Case is ready for service and LCR also received. And matter may be fixed for hearing, lordship. And 2015 matter.
In case this matter may be posted for hearing after vacation, my lord. Or at your lordship, one and a half.
okay, after vacation, because it's difficult these days. Okay. Mr. M.H., heard Mr. M.H. Rajgopal and counsel for the appellant, Mrs. R. Chaudhary, and senior counsel assisted by Ms.
S.P. Mutaja.
S.T. Murtaza, and counsel for respondent numbers
1 to 4.
1 to 4, and Mr. K.K. Bhattacharya, and government advocate appearing for respondent numbers
5 to 8.
5 to 8.
15 and 16 are also there, Rashid. The sub-register, Karimganj, Sadar, PO and PS district. 15 and 16.
Okay, 15 and 16 also. And it may be mentioned that the names of respondent numbers 9 to 14 have been struck over. Next, accordingly, the case is ready as regards service and the PCRs are received. As this is a 2015 matter, this is the matter for hearing on, give a date in beginning of July.
Yes, sir. Can it be on 16th of July, Thursday?
15th.
Yes, Rashid, July 16, Thursday.
Yes, Mr. Rajbhavan.
July.
Okay.
Apply.
For orders, item 23.
May it please your lordship. Service regarding respondent number 5 and 6 is not complete yet, lordship. As per office note 1626, answer notice have been received from respondent 5 and 6.
But on 16/12/25, some hearing had taken place. A decision was taken at one time to go ahead without.
On which date?
My note on 16/12/25. Some hearing had taken place and I had appeared, my notice there. Fixed for, and after that it was fixed for further hearing.
No, that after that the certain question law has been framed.
Paper.
You find out the correct address now?
Yes, lordship.
Uh,
Hello, they can take instructions from their client that if they want to take a paper publication also.
No, not required. First, we must serve it in the proper address. So she will find out the proper address. Miss
S. Musahar.
S. Musari, learned counsel for the appellant, has referred to the office note dated 1/6/2026, where the notice issued by speed post was returned with postal remark, no such person in the address. Return to sender. Accordingly, the learned counsel for the appellant shall obtain instructions as to the correct postal address of the respondent numbers 5 and 6. And if there is a change in address, comma, the petitioner shall file an affidavit to bring on record the correct postal address. Next para. List on, give a date after 2 weeks. It's a 2018 matter, we are giving 2 weeks, find it out by then.
Highly obliged.
Twenty-four.
Thank you, Lord. Thank you, Lord. So office note dated 1/6/26. Unserved notice has been received with regard to respondent number 2C and D.
Address is not known.
Address is not known.
You find out the correct address and bring it on record.
Madam, we need some time to get the correct address.
It's a 2018 matter, we'll give you 2 weeks.
Madam.
Mr. D. Majumdar, on counsel for the appellant has referred to the office note dated 1/6/2026. Indicating that notice on respondent was 2C and 2D have been returned back with postal endorsement, address is not known, returned to sender. Just accordingly, the learned counsel for the appellant shall obtain instructions as to the correct postal address of respondent numbers 2C and 2D, and bring the same in, and if there's a change in the address, an affidavit shall be filed to bring the correct address on record.
Much obliged.
List on after 2 weeks.
Much obliged.
Item 25.
This case, Lordship, we prayed for implement ourselves in a specific suit between plaintiff and defendant, Lordship. So plaintiff filed objection, but defendant did not file any objection. When we filed this CRPIO, Lordship, we issued notice to defendant also, but the service could not be served. So I have filed one IA 1633 for striking out the name of defendant, Lordship, from this CRPIO. Lordship.
Respondent number 3,
Yes, Lordship.
they file an IA.
Yes, 1633, petitioner, we have filed. Present issue is between the petitioner and the plaintiffs.
In 1633, say, this is our children, and it is nothing assisted by Ms. S.T. Amarkazat, on the counsel for the applicant. Also heard Mr.
A. Islam on behalf of respondent
E.
one.
E. Islam,
Yes, sir.
learned counsel appearing on behalf of Mr.
1 and 2.
Respondent number 1 and 2.
Actually, you're the counsel on record.
Yes, sir.
Oh, okay, learned counsel for respondent is 1 and 2. Next para. The senior counsel for the applicant has submitted that the notice on respondent number 3 could not be served, and as the relief sought for is only against the respondent numbers 1 and 2, he prays that name of respondent number 3 be struck off from the area of parties in the connected CRPIO 167 of 2023. Next, said prayer having not been objected to, stands allowed. This application stands disposed of. And the CRPIO will say, third space, in view of the order passed in IS Civil 1633 of 2026, the name of respondent 3 is struck off. Yes, now what is the matter about?
Lordship, we will file amended cost title and then matter may pick for admission hearing. Or Lordship, in this case, what happened? The respondent 1 and 2 are the plaintiffs in a suit for specific performance of contract. Again, respondent number 3. The suit land attracts my property, so I have filed one application praying to implicate myself in the suit. The learned trial court held that specific performance of suit third party cannot be implemented.
Correct, that is the law.
Lordship.
That is the correct law.
But Lordship, there is a judgment I have found that K. Abraham in a specific performance of suit also a person can be implemented, Lordship.
Let us see.
Copying anything. Paragraph 10 regarding the first aspect.
This order will not be applicable.
And Lordship, another one, 2007, that is Sumti Bai and others. Relevant paragraph is
On
9.
tax issues on a different footing.
They are
Here,
Lordship, the defendant number 1
2 came forward and asked for the name to be deleted.
Yes,
Plaintiff files an objection saying that no, it is my suit. I want this to be a complete adjudication between parties.
Lordship.
This is passed under that. This is not an application under one order to impede someone else.
Lordship,
Yeah.
that was for deletion of the name of defendant number 2 under order 1 rule 10 to Lordship. And in this Sumti Bai case, paragraph 14, your Lordship will find the last page. In view of the aforesaid decisions, we are of the opinion.
Paragraph?
Paragraph 9 and 14. As per Sumti by Lordship, if I can show that I have a title over the property which is in dispute in a specific performance of contract, then I can be implemented.
Okay. You file an amended cost title then.
Lordship. Lordship may fix this matter on a date for admission hearing.
You understand, sir? The learned counsel for the appellant shall, petitioner shall file amended cost title by handing it over to the AOJ Civil Division section for incorporating it in this application and for updating the CS data. List the matter in the admission column on due date after 2 weeks.
15, 16, any date, Lordship.
Give a date.
Obliged. Interim is there, Lordship.
Yes, item 26.
My pleasure, Lordship. Lordship, here me previously last order 6/5/26.
Yes.
So here there is an inadvertent mistake. Instead of issuing notice upon the deceased respondent number 2, notices are issued upon the main respondent. That is why the office note has reflected the respondent number 2 has died. In fact, I have made the inquiry. The legal heirs of respondent number 2 are still alive. Legal heirs of respondent number 2 are still alive. So Lordship may allow me to take steps upon the legal heirs of deceased respondent number 2.
This IA is for condoning of delay.
condonation of bill,
Delay has not been condoned.
not been condoned.
Who has died?
Respondent number two,
He has died.
died,
Have they been impeded?
not implemented, my lord,
Then
notice.
the notice cannot be issued on respondent number two. You have to impede them first.
Notices were issued, my lord, initially.
No, no, this will not happen. You see, in this, in connection with this, in this IA 307 of 2023,
Yes,
you have filed IA 3008 of 2023 for substitution,
substitute
correct?
and abet.
Now, look at the cost title of this application. And then you say here that the second appeal, in the second appeal, so-and-so died. And therefore you want an application for substitution. So this will mean that the application is in connection with second appeal. So delay, conversion of delay is for what?
For substitution of respondent number two.
Oh, okay, 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 okay. Okay, I was in a misconception. Then the notice will go in IA 3008.
2007, my lord, in delay application.
In connection with the 3007,
Right.
the representatives have not been brought on record. So your application for substitution, two thousand eight is,
For substitution.
or 22 rule 4.
Four.
And for this delay, there is 3007 has been filed.
Yes.
But why you did not impede them here?
2009 is for setting aside everything.
For even for condemnation of delay, there will have to be parties here.
Yes.
This is not required.
And my lord, I may take steps in all the three IAs.
No, but in this number 2, my Mangal Singh Boro is again a deceased person. When you are applying for substitution, the condemnation delay will also be for that.
Cost title, my lord, it is there, page number 2.
Mangal Boro is, you say, has died.
Yes,
And then there are two legal representatives
yes, two wives.
for which you have filed 3008.
Yes,
You have disclosed these names here. These are not parties here.
not practice. That is
Then how
what,
will you issue notice? In condemnation of delay also, there are necessary parties.
unless in the cost title I have reflected. Cost title I have reflected. Page number 2.
Oh, acha, I was looking at the RSA constable. Okay, you are right. Okay, I missed out that. Mr. G. Bahadur, then counsel for the applicant. It is submitted that the respondent number 2 has
in the connected appeal has died, and therefore application for substitution has been filed along with separate application for setting aside abatement, and this application has been filed for controlling the delay of 159 days beyond the period of limitation in filing an application for setting aside abatement. Stop. Next accordingly. Having regard to the order dated 6/5/2026 and the office note dated 17/3/2026, or the applicant is directed to take steps within 2 days for service of notice on the legal representatives of the deceased respondent number 2. First of the notice is made returnable on so and so. The learned counsel for the applicant is permitted to correct the postal receipt number and submit postal tax report prior to the exit of listing. List on so and so. Alia. This is an okay. This is in 2007 only. 2007. On their appearance, then we'll issue notice on that. Alia.
Item 27.
SP, the Lordship, is this matter already in the hearing list, Lordship? So kindly fix a date for hearing of the matter, Lordship. In this case, while filing the title.
This is ready as regards service.
Service ready, Lordship. And LCR also received. In title appeal, I have filed one condonation application that was rejected, Lordship. So a short date may kindly be given.
Okay. Dates for hearing in this matter will be fixed later on because this is 2024. We are now having a pendency of 2010.
Yeah.
So right now we are not posting a date for hearing. We'll give it after. We are listing it for orders after vacation, and then we'll fix a date for hearing.
Lordship, this is only a condonation. My condonation application was rejected by the first appellate court. First appeal not yet heard. So I am on that only. Condonation application was rejected, Lordship. Not on merit, Lordship. If I could satisfy this court, then my first appeal will be heard by the learned first appellate court.
Okay. Where is that order?
Impugned judgment and order in title appeal, page 71, Lordship, in RSA 160. Paragraph 31, page 94.
But this is our children, senior counsel assisted by
Yes, Ahmed. Yes, Ahmed.
S. Ahmed, learned counsel for the appellant. No representation from the respondents. They have not appeared.
No, Lordship. Service complete.
Unresponded despite service of notice. In view of the nature of issue involved. This is the matter for hearing. When do you want?
Lordship, if possible, in this month.
Make it 23rd June, 2026. The 23rd will be the first vacation. No, it will be 18th, 18/6.
Deeply obliged.
Maybe 5 minutes late in.
I'm paying for abbreviation of item number 48. Lordship. Earlier also is the listed for several times but could not reach. And one of the respondent is completely bedridden, Lordship. So Lordship may take it at 3 today. This is my humble prayer before your Lordship. Earlier also it was listed. Item number 48 in admission.
49.
48. Please. Please.
We'll try to.
For orders, item 28.
Yeah, President Lordship, on last occasion, the names of the legal answer respondent number 2, Roman 3, has been implicated now. I have been informed that my senior friend is going to appear for the legal answer.
We will file wakalatnama, Lordship.
For respondent numbers 2-1 and 2-2.
Two Roman 3, Lord.
Hmm?
2 Roman 3.
Or 2-1 and 2 Roman 3.
2-1 has also.
No, on the paper, Fatem Bepari, his legal heirs,
Certain paper.
2 3.1. 2 Roman 3.1, 2 Roman 3.2, Lordship. 2 Roman 3 died. Minor prisoner age New Zealand. Age to be minor. It was 20 years. Children were not calculated. Lordship will find page 5, the name of deceased in.
No, because I suddenly remembered in this application,
Lordship. It's a party would take-
para 3, the statement is made, the advocate for the respondent submitted a notice to the advocate for the appellants informing that the respondent number 2-1, Rabia Beva, and 3, Hatim Befari died on so and so respectively.
Yes,
It may be stated that respondent did not inform about the death of respondent number 2-1, Rabia Beva. And therefore, you have made this application only for 3.
Because
This 2-1 has died or not?
2-1 legal heirs, my lord, already on record. Others are the legal heirs.
But that's not you have said.
I have made a prayer, my lord, to strike out page number 9,
To strike out their names.
to strike out the.
Okay.
Rabia Bear legal heirs are already on record, Lordship.
It's okay, but there was no order passed and this statement is a bit confusing. And you will be appearing for all the representatives of 2-3.
Yes, Lordship.
That is,
Three persons are minor, Lordship.
it's okay.
2, 4, 5, 6 are minors, so I will file wakalatnama for, and mother will be
3,
representing.
4,
them.
5, 6 are minors.
Yes, Lordship. So mother will represent them.
5, 6.
Anwara Bibi will represent.
Okay. And Babu Khan, who is,
Babu Khan signature given, Lordship. Khan.
okay, he's adult.
Yes, Lordship.
Okay.
Khushi Khatun also major.
So only 3, 4,
4, 5, 6.
4,
Lordship.
5, 6.
They have wrongly written as 2.3.3, 2.3.4, 2.3.5, and 2.3.6 are minors. This is wrong, Lordship. Only 4, 5, 6 are minors.
Okay.
Khushi Khatun is aged about 20 years.
Okay.
There is a notice here, Lordship.
Bharadwaj and counsel for the applicant. So he has submitted that during the pendency of the RSA 134 of 2025, comma, respondent numbers 2 within bracket, small Roman 1, Rabia Beva, RABIYA, BEWA, and respondent number 2 within bracket Roman 3, Hatim, HATEM, Befari, had expired. Submitted that the legal representatives of respondent number 2-1, Rabia Beva, are already on record. Accordingly, he praised that the name of respondent number 2 within bracket Roman 1, Rabia Beva, be struck off. This prayer is allowed. The name of respondent number 2 within bracket 1, Rabia Beva, is struck off at the risk of the appellant. Now, next para. Mr. R. Chaudhary, learned senior counsel, assisted by Ms. S. Ahmed, learned counsel, has submitted that she has appeared for respondent, for the legal representatives of respondent, deceased respondent number 2 within bracket 3, Hatim Bepari. So it is stated that the wakalatnama is filed by 2 within bracket 3, within, after that one, numerical 1, and 2 within bracket 3, bracket closed, numerical 2, Babu Khan, and as the as the parties at serial number 233, 234, 235, and 236 are minor. Oh, also 3.
Also,
3 is wakalatnama.
3 filed wakalatnama.
Then 233 has filed wakalatnama. And as
We are going to file, Lordship.
okay, we're going to file.
Yes.
234, 235, and 236 are minors, comma, they are represented by legal representative at serial number 231, Anwara Bibi. Full stop. Next para. Accordingly, in view of the submissions made by the learned senior counsel for the legal representatives of the deceased respond to 2, 3. The case is ready as regards service. Full stop. List on. You will file by when?
Sir, amended cost title,
Amended cost
after filing of amended cost title.
No. In this, your service, your appearance has to be completed. You will file your wakalatnama by when?
By tomorrow I can file, but Lordship, the impleaded respondents were not yet amended in the main regular second appeal.
We'll have to do, but we can't do it at your, without your wakalatnama. We can't accept your presence and then substitute them.
Substitution
you-
already allowed as per my learned friend says. Substitution allowed, he says, Lordship. IA already disposed.
IA disposed.
3694 already disposed.
8/12/25.
Okay, this is a dispose 8/12/25. Okay.
Yes.
Okay, then just say, pending appearance for the legal representatives or this is the respond number 2 within bracket 3, the as application for impleading being IA civil 3694 of 2025 has already been allowed by order dated 8/12/2025. The appellant shall file the amended cost title of this appeal within a period of 3 working days. And a copy thereof along with the memo of appeal be provided to the learned instructing counsel for for the legal representatives or deceased respondent number 2, 3. Full stop. List again in the orders column on, give a date, this goes after vacation. So 3 days time we are giving you to have the amended cost. 15th of July. 15th of July, then we shall be filing.
Alia.
Item 30.
Lord, frankly speaking, we have not a good case then. Because my lord, earlier, one title suit was filed in Dhubi. That was dismissed. Then first appeal was filed. That was also dismissed. Then RSO was filed. That was also dismissed. So party had the remedy only in Supreme Court. But instead of that, due to wrong advice, they again filed title suit. Then that was dismissed on the ground that already matter is adjudicated. Then they filed first appeal, that was dismissed. Then again second appeal, that was in defective list. The advocate concerned at that time did not rectify it. So that was also dismissed. Now we have filed this review petition only, my lord may can not record it, but our intention is to go to Supreme Court. But unless some order is passed by High Court, we cannot go.
Delay of
This
3,
is the
4,
first time
8,
I
5.
have been against.
Delay
Before
of
that,
3, 4, 8, 5 days.
yes.
My lord may leave it to the discretion of the Supreme Court, my lord. Leave may be granted for them to, they can, if they want, they can go, my lord will not obstruct it. That kind of order may be passed. In the olden days, there used to be a leave petition filed in the High Court. Only after the High Court grants permission, one can go to the Supreme Court. Something like
Right
that.
now we are dealing with condemnation application.
Yes, my lord. My lord, this is not a writ petition also. That is the problem now.
Third, what we say, Amir Mohammed, then counsel for the applicant, and Mr. K. Bhattacharya, then a government advocate appearing for respondent numbers
Respondent number 3.
3. Next para. This court by order dated 6/5/2026 issued notice which is made returnable on 3/6/2026. So from the office note dated 30/5/2026, it is noted that as per the postal endorsement, the respondent number 1 had already expired. And in respect of respondent number 2, the postal remark is that no such person in the address. Next one. However, in view of the nature of the order which is proposed to be passed, at this juncture, issuance of notice on respondent numbers 1 and 2 is dispensed with. Next para. From the contents of the application, but you've seen that this is an application filed under Section 5 of the Limitation Act for controlling the delay of 4200 days beyond the period of limitation in filing the connected review petition against the order dated 20 January 2014, passed by this court in RSA 18 of 2014. Next para. On a perusal of the order dated 20 January 2014, passed by this court in RSA 18 of 2024, which is appended to the unregistered review petition. It is seen that the present petitioner and the respondent number 1 and the respondent number 2 had purchased 3 contiguous plots of land from his owner in the year 1995 by 3 separate sale deeds. So, the case of the petitioner is petitioner is that on 5/7/1996, here to be applicant. The applicant and the respondent number one had made an agreement, unregistered agreement to leave vacant land between the two plots of land measuring 1 by 2 feet in breadth and 104 feet in length from their respective plots to be used as a common passage. To stop. Accordingly, as nothing materialized, the applicant instituted PS 283 of 2005 seeking a declaration. To stop. This court, on consideration of the pleadings and evidence, arrived at the conclusion that on the perusal of the said agreement, within bracket Exhibit 4, and on perusal, the court recorded a finding that the agreement was executed on 5/7/1996, and the same bears the signature of the signature dated 18/12/1997 of the Judicial Magistrate First Class Dhubri. Therefore, this court arrived at the conclusion that the agreement was made on 5/7/1996, and the same was placed before the learned Judicial Magistrate First Class on 18/12/1997. The learned magistrate had put his signature on the agreement on 18/12/1997. So accordingly, this court concurred with the finding of the learned courts below that the agreement was made on 18/12/1997. And accordingly, as the question whether the agreement was made on 18/12/1997 or on 5/7/1996, being a question of fact, which was the content finding of fact, comma, finding fact in respect of the date of execution of the agreement, this court found no substantial question of law, and accordingly the appeal was dismissed. Full stop. Accordingly, the connected review application was filed on 21/8/2025. And according to the calculation made by the registry, comma, the delay was calculated at 4200 days. Which the petitioner, which the applicant disputes and projects that the delay was 3485 days. Taking into account the order dated 10 January 2022 passed by the Supreme Court of India in MA number 21 of 2022, in MA 665/2021, in SMW within bracket C number 3 of 2020, that the period from 15/3/2020 to 28/2/2022 shall stand excluded for the purpose of limitation with regard to any judicial or quasi-judicial proceedings. Next paragraph. The court also takes note of the fact that clearing right to the path the applicant had previously instituted TS 383 of 2005. Most of the said suit was dismissed by the Court of Learned Munsif, Dhuri. Thereafter, the applicant number one, namely Jebun, Jebun, Nehar, Nehar, Hawk, had filed a appeal which was numbered as TA number 61 of 2020. So, however, they said appeal was also dismissed. How the first appeal was also dismissed. Stop. Thereafter, the concurrent finding regarding dismissal of the suit and the appeal was assailed by the applicant number one by filing a regular second appeal, which was numbered as RSA 18 of 2014. So they said second appeal was dismissed by order dated 20 January 2014. Full stop. The order dated 20 January 2014 passed in RSA 18 of 2014 had attained finality. However, the applicant number one once again filed a suit which was registered as TS number 301 of 2014. The Learned Munsif number 2, Dhuri, by judgment dismissed TS 301 of 2014. The decision of the second suit was assailed in appeal, which was registered as TA what is the title appeal number?
69, 2015.
69 of 2015. However, this first appeal in the second suit was also dismissed. Stop. Thereafter, the petitioner, the applicant, number one, filed regular second appeal, which was filed under filing number RSA 1661 of 2018. There were mistakes in the said appeal, which was not rectified. And it is the admitted case of the applicant that the said second appeal was bearing filing number 1661 of 2018 was dismissed by order dated 14/8/2018. In the meanwhile, the original plaintiff, namely Jebul Nahar Haq, had passed away, and the present applications on the legal representatives of the deceased plaintiff in TS 383 of 2005 and TS 301 of 2014, and they filed the connected review application for review of the order dated 20 January 2014, by which RSA 18 of 2014 was dismissed. Next paragraph. As the next paragraph, as the proceedings of RSA 18 of 2014 was dismissed by order dated 20 January 2014, the applicants would not get the benefit of extension of limitation by virtue of order dated 10/1/2022 passed by the Supreme Court of India, referred above. So therefore, the delay would be 4200 days as calculated by the registry. Next paragraph. The original plaintiff, namely Jebun, Jebun, Nahar Haq, Nehar, Nahar Haq, cannot be said to be not aware of the dismissal of RSA 18 of 2014, and therefore filing of subsequent suit being TS 301 of 2014 appears to be a misadventure. To stop, nonetheless, the original plaintiff had assailed the dismissal of TS 301 of 2014 by filing of first appeal and thereafter approaching this court by way of a second appeal. On dismissal of the second appeal in the second suit, which was by filing number 1661 of 2018 by order dated 14/8/2018 for not rectifying the mistake. Appears to be good ground to not exercise not to condone the delay of 4200 days, so as to enable the court to exercise the power of review against order dated 20 January 2014 passed in RSA 18 of 2014 as on the ground that no substantial question of law was made out for admission of the appeal. Next paragraph. Accordingly, having found that no case is made out on merit for condoning the delay of 4200 days beyond the period of limitation in filing review against order dated 20 January 2014, passed in RSA 18 of 2014, this interlocutory application stands dismissed Consequently, the unregistered review petition bearing filing number 10900/2025 shall also stand dismissed.
Hello.
Item 31.
Net visual issue, service is completed. The matter may come for admission. Service is completed. The matter may come for admission.
What is the order and the challenge?
Challenging the order dated 20 December passed by learned district judge for by framing 17 numbers of additional issues.
You are the plaintiff or the defendant?
Where the we find the we are the present petitioner.
The petitioner is the plaintiff or the defendant in this suit?
Plaintiff, we are the plaintiff.
Plaintiff in this suit. Where is this petition number 117/3?
Lordship is a assembly review that we can find.
The applicants have filed an application for framing 17 number of additional issues. Why petition number 11?
Where is that petition? Which page?
Um, Lordship, page number 169.
Mr. Roy is not there. Lordship. Respondent.
Lordship,
Counsel for the petitioner is present. There is no representation from the counsel for the respondents. So for hence of justice, the matter stands adjourned today. Released on maybe tomorrow. 4/6/2026. So it will make clear that if the respondent remains absent on call on the next date of listing, appropriate orders will be passed.
Article 2.
Not legal also.
Yes.
Not legal law. Question on divorce petition is pending in the court of district judge Gauhati. What is the petitioner filed a transfer petition from Gauhati to court of
ID card has not come. You'll have to take steps again.
my lord. Airport service report will as per the office note dated 35/2026.
Neither ID card nor you have taken steps long back. 8/4.
Step was taken at 6/4/2026. In the order dated, my lord, 27/3/2026, my lord. If you notice, interim order shall be considered on the next date fixed, my lord. I pray before lordship, my lord, some children will be.
Okay. Mr. F.A. Hassan and counsel for the petitioner. As per office note dated 30 May 2026, neither DD card nor answer notice has returned. Accordingly, the petitioner shall take first steps within 2 days for service of notice on the respondent by speed procedure. Next, by the honored counsel for the petitioner shall collect the postal receipt number and submit postal track report prior to the next date of listing. Next para. The honored counsel for the petitioner has referred to order dated 27/3/2026 and has prayed for interim relief. Next para, considering the fact that the petitioner, who is the estranged wife of the respondent, is seeking transfer of the matrimonial proceedings by filing this application under section 24 of the CPC. The court is inclined to stay the further proceedings of TS within bracket divorce, bracket was case number 64 of 2023, pending for disposal before the court of Dhanet District Judge Dhemaji. Next para. The petitioner shall produce a certified copy of the order before the state level court to bring the order to the notice, to its notice, and to make the order effective. Next para, list on after 5 weeks. Take first steps within 2 days. Item 33.
Meet legal. If other steps are complete, my lord, the sole respondent has appeared.
Decree against a dead person.
it has been set
It
aside.
has been set aside.
It has been set aside.
Parties have settled the matter.
No, no, my lord. The execution case was dismissed because it was, decree was passed against a dead person. We prepared a revisional court set aside the order, remanded the matter.
The estate was sufficiently represented, my lord, on that ground.
Page
Okay,
54,
so why is the CRP now pending?
My lord,
in the particular execution proceeding, my lord, they have preferred an application for restoration of the execution proceeding. So we had not been served a copy, my lord, and the executing court partly issued the writ, my lord. So against that, I had preferred an application under section 47, my lord. At least to demarcate the entire suit property and issue a commission, my lord. So that petition was pending for consideration, my lord. Then I preferred a hearing.
Lordship will find that at page number 54, the last
Number?
54. Last revision order, Lordship.
So what has happened with respect to direction of 14, paragraph 14(2) at page 54? What has happened thereafter?
Thereafter, 17, my lord, I filed an application before the executing court to proceed with the execution case. That thereafter, the executing court allowed that application. That your lordship will find at page number 62, annexure 80.
82.
Yes. 16/10/2025. In this order, the judgment debtor did not raise any objection. So far, our application is concerned.
And where is the decree?
At page 21.
25.
And where is your application under section 47? Is it page 65?
65, my lord.
And who is this Dildar Alam?
Is the son,
Huh?
son of original defendant number 1.
My lord, may I pay one thing, my lord? My lord, inadvertently, my lord, in the cost title, my lord, the address of the petitioner is wrong now. So, I may be
No,
allowed.
those things, since he has appeared, he is not taking that issue. The issue is that now, as a third party, you are also the representative of the deceased judgment debtor.
Yes.
So you will be bound by the decree. You say that you have not been heard. So the civil judge, junior division number 2 will take up the, junior division number 1 will take up the hearing.
Lordship, if Lordship may produce page number 63. At the bottom, my lord.
Yes.
The landed counsel for the judgment debtor raised no objection to this. So I
No,
felt
that's
it
okay. He's coming as a third party, but his status is that of the legal representative of the deceased, the judgment debtor. His file an objection, that objection has to be heard.
it is fixed on 18/6 before date.
Yes,
18/6.
18.
So we close this revision.
Look,
There's no ground to challenge it here. And Mr. A. Dekal and counsel for the petitioners, and Mr. G. Bharadwaj, then counsel for the
Full respect.
sole respondent. Next para. The petitioners herein are the sons of the deceased judgment debtor. In respect of the judgment and decree dated 27/11/2001, passed in TS 45 of 1973, right?
Yes, yes, yes. Lordship, date is 29/11/2000.
29/11, not 27/11.
29/11.
Okay, 29/11. Pushpa. However, as third party to the proceedings of title execution number 12 of 2013, the petitioners had appeared before the learned executing court, IE, civil judge within bracket junior division, bracket close number 2, Gwalpara, filing an application under section 47, read with order 26, rule 18 within bracket small a of the PPC. Next, right. Appears from the documents appended to this application that the objection is to, the objection raised under section 47, read with order 26, rule 18 CPC, which was filed by petition number 14/26, was taken on board, and by order dated 6/1/2026, the matter has been fixed for hearing as before. Full stop. It has been submitted at the bar that the next date of the proceedings of title execution case number 12 of public 13 is fixed on 18/6/2026. Full stop. Therefore, comma, the learned civil judge, in bracket junior division, bracket was number 1, Gwalpara, is requested to take up the objection and dispose of, and make an attempt to dispose of the same as early as possible. Next para. In this application, the petitioners have prayed for setting aside the order dated 16/10/2025 passed by the Learned Executing Court, by which writ of delivery of position was issued. And the petitioners have also prayed for stay of the execution proceedings. Next para. In the considered opinion of the court, comma, neither the order dated 16/10/2025 can be stayed by this court in exercise of neither order dated 16/10/2025 nor the proceedings of TX number 12 of 2013 can be stayed by this court in exercise of jurisdiction on Article 227 of the Constitution of India, as there is no apparent perversity in the order dated 16/10/2025. Next para. As the petitioners have filed an objection under section 47, this court refrains from making any observation as to the issue raised in by the petitioners in petition number 14/2026, as it would highly prejudice either of the parties. First of, as the said petition number 14/2026 already stated for hearing on 18/6/2026, comma, any adjudication by this court at this stage under Article 227 of the Constitution of India is impermissible. So accordingly, without it is held that there is no good reason for this court to interfere with the impugn order dated 16/10/2025 or to stay the proceedings of execution, as the Learned Executing Court has already posted the matter for hearing on petition number 14/26. Next para, accordingly. In terms of the request made by the court, the Learned Executing Court shall do the needful in accordance with law. So with the aforesaid observations, this application stands closed. Next para, nothing contained in this order shall prejudice any of the parties when the execution proceeding is held.
Yeah, one seven. Please to consider my petition.
So definitely it is put away and it will be considered.
Because my lord, as per my instruction, on the last occasion, the court had observed in the order that it will follow whatever this honorable court passes, the order. It is,
Okay.
I do not have the certified copy, my lord, now.
No, that's okay. But do you subject yourself, both of you, do you subject yourself to the wisdom of this court to pass orders in 227?
No.
No. But if you give us the liberty, we will be very happy to do it. The problem is there. If you pass an order, then your remedy will be remediless. But this court has already made an observation in the earlier CRP. That will be binding on the trial court, the executing court now. The boundaries have been earmarked already in that earlier revision.
So that was my only grievance, my lord.
In fact, in the application, they have already stated that they are in possession.
It's okay, we are not saying anything.
Because the decree was past 20 years early, so that was my grievance. Public.
May question to the effect of the so don't. Okay, good. Orders specifically. What আছে নয়? এখানে orders টা করে দাও। What is the long plate? Before raising law. Item 34.
We have taken steps upon the sole respondent. The office note dated 35/2026 indicates that the neither ID card nor answer notice has been returned back. Having maybe awaited lawsuit. We took steps on 7/5/2026.
Okay, heard Mr. N. Hasan and counsel to the petitioner. Whereas notice has been issued on the respondent on 8/5/2026 from the learned counsel for the petitioner is given liberty to collect the postal receipt number and to submit postal track report prior to the next date of listing. Next part listing due date after 2 weeks. Okay, you're not paying maintenance.
I am paying, but lordship, not regularly. I paid something.
Then we make it clear. It is made clear that there is no stay operating in respect of the order for payment of maintenance. This one says so.
Public.
35.
Yes, Mr. Dubey.
There was a default on our part in taking steps, but if we could take yesterday only. But
Okay, we'll take it by tomorrow.
we have taken yesterday.
Yesterday, okay. Mr. R. Dubey, learned counsel for the petitioners has submitted that there was an inadvertent default in taking steps. First of, however, it is submitted that steps was taken on 2/6/2026. First of, next paragraph. Notice is made returnable on, give a date after 5 weeks. Awaiting service of notice on the respondent. Just inform the section, Mr. Dubey, otherwise, again, there will be a mismatch in the orders of.
Mal will go.
Lordship, as per office note 35/2026, neither ID card nor answer notice received.
Not the-
He appeared, I think, respond number 1 to 6, Lordship. There are other respondents also,
How
total
many?
12 number of
1
respondents.
to 6.
You have for 1, 2, and 3.
No, 1, 2, 3, 4, 5, 6.
6, okay.
Sir, no file
So
yesterday.
now 7 to
12, Lordship.
7 to 12.
Yes, sir. That is awaited, Lordship.
You have cross-file file
Yesterday, sir.
yesterday. Okay. Just set up yesterday. What happened in item 36? Is it available there? No, in the CS system. Yeah, PIO 151. So this would be by charger and counsel for the petitioners. So Mr. NM, the third NM. Your name would be?
SC count.
Mr. SD Khan. SS Khan.
SC.
SD.
SC.
I'm sorry. You are appearing along with Mr. NM Datta.
And then the CC.
You are there.
And
Okay,
then
yes. Okay.
Element Abhishek Kumar count. Element Abhishek Kumar count.
This is Khan and counsel along with Mr. NM Datta and counsel. If there appears for respondent numbers 1 to 6. Stop. The service is reported, service is awaited on respondent numbers 7 to 12. Stop. The learner counsel for the petitioner has given liberty to collect the postal receipt number and to submit postal track report prior to the next date of listing. Steps was taken on this date. On 21/5.
On 25.
21/5. Steps was taken. Fix the matter on. Since you are coming from outside, when do you fix it? When do you fix the matter? Service on others is not complete.
Before vacation. Before vacation or after vacation?
No, whatever suits you, tell us.
If after vacation, then it can be fixed on 20 or 21 July.
Okay, 20 July.
Stay order may kindly continue. There is stay order.
Okay. Interim order passed on 18/5/2026, stands extended till then.
Published.
Okay, but have you produced the certified copy there?
Yes, sir.
Into the trial court, you have produced, okay.
Public.
You just collect the postal receipt number and the
Yes.
postal track report for that. Item 37.
Completely. This is IA, and I'm for the applicant. So, in the last video, Lordship has allowed time for filing objection by the opposite parties on the condition that they have produced maintenance amount for 1 month. No objection has been filed.
Hmm?
No objection has been filed. I have not received any objection.
Today we are filing the amount, Lordship.
We are,
The entire amount which has not been paid till date, we are there in filing this amount. We are just paying the amount today itself, Lordship. We are there in the concerned court for payment of the amount. But since the record is not there, it's a dispose of case. So we are this.
Not disposed, but
Yes, the interim application has been disposed of.
okay. So we take it up again on Monday then?
Yes.
so this IA can be, since they have been paying.
Amount, this particular
IA
amount,
is not of
7,500, this particular application was filed before the concerned family court, and there has been disposed of with a direction to make the payment. But since 2025, because of some personal financial issue, he has not made the payment. But yesterday also, you went to the concerned court for making the payment.
It's okay, you make the payment.
Yes.
Till then, we are not closing this application. You report on Monday.
Then Lordship may fix the matter for admission, because the main issue is also required to be taken into account. Next, if this matter is taken up in the next week, this
Both the matters may come up together.
yes, I will be there with the main petition. Yes.
Okay.
Only thing is that I have to show something with regard to the fact the amount has been paid. So there is no requirement of filing objection on this.
That's okay.
Yes.
We'll,
So
get this
dispose of
carefully.
application.
Hmm?
That particular application under section 24, that has been disposed of by the concerned family court. So pursuant to that, this payment amount was to be paid till.
Yes, that's why we are awaiting only that.
Application, yes.
Because we have put the respondent to notice as to why litigation cost was not being imposed.
Litigation cost, because at my peril, because my application was there with regard to the fact that I want to adduce evidence, and that has been rejected. So there is the only very limited
That's
share on
okay,
the part
but
of the
since
litigation.
that is there, you just make the payment and then tell us, then we'll see this order.
Exactly, Lordship.
Both sides are represented. Mr. S.P. Chaudhary and counsel appearing for the respondent has submitted that the maintenance amount would be paid in course of day to day. Accordingly, the matter stands adjourned today to enable the learned counsel for the respondent to address the court as to whether the maintenance amount has been paid in the meantime. Next, para. List the matter on 8.
Lordship, 8, and you some difficulty. Can you go on 10?
10, okay, based on 10, 6, 2026 for consideration of this interlocutory application as well as the connected CRPIO 371 of 2025.
This matter may come up in the admission column.
Okay. According to list on Wednesday in the admission column.
Okay.
Hello.
38.
If I may, my lord. I is for condonation of delay of 106 days in preferring the connected second appeal. My lord, at this point, notice may be issued, my lord.
Notice has already been issued. You have also taken steps.
Yes, yes.
You heard the learned counsel for the applicant. The learned counsel for the applicant is given liberty to collect the postal receipt number and to submit postal track report prior to the next date of listing. List again on, give a date after 2 weeks.
Item 39.
Deeply afraid.
May it please your lordship. In terms of the office note dated 35/26, neither ID card nor unserved notice has been.
They want to know. But Ms. S. Sharma, and counsel for the applicant. For office note dated 35/2026, neither ID card nor return, nor answer notice is returned back. Competent counsel for the applicant is permitted to correct the postal receipt number and to submit postal track report prior to the next date of listing. Next, list on so and so, same day.
On the 19th, my lord.
Lordship, I am appearing for 1.2 and 1.3 order.
Okay, just record the presence. Mr.
R.A. Mazumdar.
RM,
R.A. Mazumdar. Yesterday evening I have filed.
RM,
R.A. Mazumdar.
your surname I'm still not catching.
Mazumdar.
Mazumdar. Okay. Then counsel enters the appearance for respondent numbers
1.2 and 1.3.
1.2 and 1.3.
1B
There's
and
no 1.2,
1B and 1C.
1B and
One.
1C. 1B and 1C. Then the service is complete.
Yes, my lord.
But what is this cost title? You have given the name of number one and then you say that one is struck off.
Struck off by order
If it is
dated.
struck off, how can the name come back again in the cost list, cost title?
She has passed away.
No, but somebody's name is struck off cannot come in the cost title again.
Yes, my lord.
Okay, 41 days delay. What do you say?
Leave it to up your lordship.
No, don't leave it.
Otherwise,
You have to make a statement.
lordship, we have received the file yesterday evening, so it needs time, my lordship.
For reading these 10 paragraphs.
No, your lordship, the file is not with me, your lordship. They have only sent the authorization. File yet to be received.
Service as Sharma will counsel for the applicant. So, your name again?
R.A. Mazumdar.
R.A. Majumdar and the council entered the appearance for respondent numbers 1B and 1C. Accordingly, the case is ready as regards service, as the name of respondent number 1A has already been struck off. In the struck off means where it is struck off?
By the order dated 1/6/2016.
No, don't tell us one. This is not of this code. So 24/6/16 is order of which code?
But the I will.
How did struck off when in the code below? Next, on the prayer made by uncounsel for the respondents, list again on 10/6/2026.
Obliged.
Item 40.
Please, your lordship. This is for substitution, my lord. Kindly page 6 of, my lord, the I, page 6.
What is the date of death?
301/301/2026.
301
26.
26.
Yes, sir.
Within time, we'll allow it.
Your lordship, no.
You are appearing for the respondents.
1A, 1B, 1C.
1A, 1B, 1C.
heard Mr. D. Sharma, learned counsel for the applicant, and Mr.
Y.A. Sarkar.
Y.
A. Sarkar.
Y.A. Sarkar, learned counsel, appearing on behalf of Mr. S. Sharma, learned counsel for the respondents. Next paragraph. This application under order 22-3 CPC, the applicants have paid for substitution of the name of legal representatives of deceased appellant number 6, namely, late Nipul Nipul Katoni Kaatoni alias Nipul Saikia, who died on 30 January 2026. Next para. As this application was filed on 29/4/2026, or the application is within the period of limitation prescribed. So accordingly, this application stands allowed. In the name of the legal representatives of respondent number, sorry, appellant number 6, applicant number of the deceased appellant number 6 in RSA 242 of 2016 is permitted to be substituted by the legal representative whose name appeared at paragraph 3 of this application. So this application stands disposed of. The appeal, you say that in view of the most in view of the order passed today in IS Civil 1454 of 2026, or the learned counsel for the appellant shall file amended cost appeal in 2 days and hand it over to the AOJ second appeal section for being incorporated in the memo of appeal and for objection of the data in the CI system. Thereafter, as the second appeal has already been admitted for hearing by order dated 27/1/2017, this is the matter for hearing on give a date after vacation. July. Okay. 41.
May I please, madam? The office note dated 1/6/26, my lord, refers the neither AD card nor the answered notice has been received, my lord.
No. Mr. K. Vishwakarma,
Yes, madam.
counsel for the applicant, in your office note dated 1/6/2026, the learned counsel for the applicant shall collect the postman receipt number and submit postman track report prior to the next date of listing. List on your date after the same date, after 2 weeks.
My lord, I have one prayer, my lord. My lord, there is one more IA pending, that is the stay petition, my lord. My lord,
We have to take, first we have to do that in all
that is
cases.
right, my
we
lord,
not-
my lord, in the meanwhile, my lord, when I filed this appeal, there is a title execution which has been initiated, my lord. The next day fix is 9/6, my lord. On the last day, when I first appeared, that is on 6/4, I have appeared and I have made a submission that an appeal has been filed, and accordingly, it is fixed for necessary orders. So 9/6 is the next date fixed, my lord. The title execution is, my lord, 53/2025, which is pending before the Civil Judge Junior Division 1, Sunitpur at Tezpur, my lord. Till that, if I may be protecting, my lord, because I am the, my lord, insurance company, my lord. Basically, if I go with the fact of the case, my lord, there was a prayer made before the learned court, the trial court, that an declaration should be made under section 108 of the Evidence Act, my lord, in the trial court by the plaintiff. I was the defendant, and what happened is, like, once the honorable trial court declares him to be under section 108, the insured amount whatsoever was there, the nominee are entitled to that. The learned trial court has rejected their claim on the ground that they are not entitled to declaration under 108. Accordingly, they have appeared for an appeal. The appeal was allowed, and automatically it was directed that I must be, they have paid the premium, since they have paid the premium, and I must be allowed to give them the amount, policy amount of 2,50,000.
The dead body is never found.
No, it was never found. Now, our contention was one of that, since the policy, when the policy holder was even alive, he had not paid his premium. It is the first premium which he had paid, that is the day of opening of the policy. But later on, it was never paid. After lapse of 2 premium, only thereafter, the person went missing. That was our contention. So, otherwise, we will be directed to pay the amount in the execution case. That is the.
So according to you, the policy had lapsed.
Yes, yes, madam. The policy was there.
The proceeding is fixed on 9th of
9/6.
9/6.
9/6, madam.
Okay, you say that. The learned counsel for the applicant has submitted that the applicant is the insurer of the insured who had gone missing on 4/6/2012, and that his dead body was never recovered. So it is also submitted that the said missing person, public insured, had paid only one yearly premium on 26/2/2010, on the day when the policy was made. And the second insurance premium, which was due on 26/2/2011, was not paid, and therefore the policy had lapsed. So stop. We submitted that. In the meantime, an execution proceedings, which is registered as
Title execution,
title execution case number
53
of
2025.
2024,
It is Civil Judge Junior Division 1.
is progressing in the Court of Learned Civil Judge, Senior Division number 1,
Junior Division 1.
Junior Division
Yes.
number 1, Sonitpur, Tezpur.
Sunitpur Tezpur.
If the decretal amount is recovered in execution, the matter would become infructuous. So it is submitted that in this respect, another interlocutory application has been filed in the order of 41 Rule 5 CPC. However, as the connected appeal has not been, as the delay has not been condoned in this application, on either the appeal under section 100 CPC nor the application under 41 Rule 5 has been registered. You see, there is a judgment of this court. It says that if the execution cannot be stayed under order 41 Rule 5, then section 151 can be invoked. But in an application under section 5 of the Limitation Act, you would not have jurisdiction to pass any order. But there are two judgments of this court. I'll forget the citation. I am very weak in memory. There are two judgments. One of Honorable Justice J.N. Sharma, where it has been laid down that it's long back, 97, 98 sometime. And under 151, it can be invoked. You'll have to file an application under that. Otherwise, the in unnumbered applications, the problem is that no orders will be uploaded in our CI system. It will not be reflected. And under 5, we don't have jurisdiction to pass that as well. That's all. Accordingly, the court permits the learned counsel for the applicant to. Mr. Nath, you have that copy? Yes. Yeah, whatever. Thank you. That was really wonderful to carry that. The court permits the applicant to file an appropriate application for the stay of the execution. But in the meantime, the petitioner is permitted to produce a certified copy of the order before the learned executing court. Let's wait for. Next paragraph. Let's look again on 14/6/2026. You've given you liberty to collect the postal receipt number and give the postal track report. Yes. The notice was issued on 14/5, so we have to wait for 1 month to take cognizance of the notice. Yes. We are giving you liberty to move this application under 151. You consider that. It's given you that link. I'm obliged. 42. Obliged, madam. Yes.
But receiving IA, praying for striking out the name of opposite party number 1 and 2, because during the pendency of the petition, they were transferred and they are posted at different places, and we could not find out their new place of posting and address. So for that, the service is not complete in respect of 1 and 2, opposite party number 1 and 2, and therefore the case is not proceeding.
You want the name to be struck off,
my lord,
1 and 2.
1 and 2, my lord.
Okay, heard Mr. A. Ali, learned counsel for the applicants. By filing this application, by filing the interlocutory application, the applicant, applicants for the petitioners in the connected contempt case have prayed for striking out the name of the respondent numbers 1 and 2. That is, their names could not be, their current addresses could not be connected. Next, the prayer is considered and allowed. Accordingly, the name of respondent numbers 1 and 2 is ordered to be struck out from the cost title of the connected con case C number 282 of 2025. So these applications are disposed of. In the contempt petition, you have to write in view of heard so and so, in view of order passed today in so and so, the name of respondent numbers 1 and 2 is struck off. The learned counsel for the applicant shall submit a amended cost title and hand it over to the contempt, AOJ contempt section for being incorporated in the contempt petition and updating the data in the CS system. And thereafter, the matter shall be immediately listed
For admission,
there is a contempt, it will not come in admission.
my lord.
Listed immediately thereafter.
Obliged.
Disposed of. Yes, 43, 44.
That is your options. Well, it is for substitution. And I was respond number 1.1 that. Then we file it IA 1805, 1807 and 1808.
Respondent number?
R 1.1.
1, 2, 1, Roman 2.
Is there a delay?
Delay.
How many days?
We filed by the IA 1805, 1807 and 1808. And the old tendency of this IA, appeal and expire.
Appellant has expired.
So we have
this
filed
301 is for appellant. There, presently we have
presently 1742
1742, yes.
minor
This is for
for substitution of the legal rights of the appeal because
appellant.
appeal.
This is within time?
No, there is delay.
How many days delay?
147.
147.
47.
You are appealing for
My respondent.
all of them.
Other.
You have any serious objection to this?
Yes.
Okay.
No, my already the in appeal substitution has been made. In appeal 301, substitution of legal rights has been, but in this case it was not done because during the
No, it's not required.
No.
Once a substitution is done
in appeal.
in any proceedings, it's a consequential effect in all the applications.
In 1805, 1807 and 1808.
In appeal, they have already been substituted.
In appeal, it is substituted. Already substituted. But in this case, it was not.
No, it's a bit, it will have effect on all. Every time you don't have to substitute for all missed cases and all applications pending. I heard Mr. N. Hawk, learned counsel for the applicant, and Ms.
P. Sharma.
P. Sharma, learned counsel for the respondents. Next, this is an application under Section 5 of the Limitation Act for pondering the delay of 147 days beyond the period of limitation in substituting the legal representatives of the deceased applicant in the proceedings of IA Civil 1805 of 2025, IA Civil 1807 of 2025, and IA Civil 1808 of 2025. Whose committee submitted that?
Hospital also corrected. The six matter that application under order 22 June 10 they filed, but it was not disclosed, but that is what is shown in the P65 by the respondent. And 439 also may not same. Yes, yes. Appeal. This order to Rule 10 application was filed by them, giving information that the respondent number 1 died. Then already we have filed the substitution, acknowledged the substitution was made. Respondent. Respondent number 4. Opposition. 4. That is also order 22, any petition filed by the my lord respondent when police respondent 1.1 died.
1, 2, 1, 1, 2.
One 1805, your lordship passed the order. Mike. Hey, my lord, that is 8, that is this one. My lord. 5, 5. Present of I number, that is your lordship. Appellants, their appellants died, that is that. Yes, not disposed of, but it is disposed of. 1740 disposed of. Might disposed. But 1805, 1807, and 1808 those you pending. Yes, Lord.
Yes, except on 1805, 1807, and on 1808. Because we have to correct the post title also. Yes. One point one actually. 1.1.
Respondent number 1, 2, Oruk Kalita. 1, respondent's husband, Jogesh Chandra Kalita. 1, 2 died, 1, Roman 2 died, Oruk Kalita.
Take note. Yes. Or Kalita died. 1.1 actually. 1.1. 1.1.
Urukolita.
Urukolita.
Yes.
No. Urukolita.
Urukolita died. Now, in the meantime, we find Urukolita died, we find mistake in the meantime, appellant died. So we one connected appeal is there. This connected appeal is there.
Appellants are different, but the respondents are same.
Same respondent.
Same respondent. Item number 43.
In item number 43. Oh, 301. My lord.
Item number 44, IS are already disposed of. Item number 44, RSA 81 of the 15, 2015.
In RSF. Also the number. No, already substituted. One point, Urukolita. Urukolita. In 301. My lord, second appeal, second one, my lord, I am not representing, my lord. Several set of advocate is there. In 44. My lord.
Supplementary next item, my lord. Supplementary item orders matter. First item I have mentioned, my lord, earlier also it was dropped. Because there are some urgency.
Eventually, my lord, if decision will be taken up today or
Item 60.
My lord, item 50 and 51 is not taken, my lord, there is an interim that may be extended, my lord. My lord. My lord. Lordship, I am appearing on behalf of respondent number 123, item number 60.
Lordship, I am for the petitioner, the delays of 48 days. Lordship, that has occurred because the first certificate copy that we have obtained, some pages were missing due to while photocopying that. IA civil number 1413/2026. Lordship, we have taken steps by Dusty, and one respondent has refused to accept the notice that we have stated by way of an affidavit already. The Dusty affidavit, service affidavit we have filed. No other way to provide them guarantee. Lordship, that details we have not put. Lordship, but what we have stated is clearly because honestly we have stated and yes. step could have been done from our, that was a mistake on our part, Lordship. We've taken steps also for the registered post. Yes, Lord.
AL Mandal.
Lordship, here we have filed another way for the stay of the operation of the execution proceeding that is pending till disposal of this condonation of delay petition. Because Lordship, the execution proceeding has already started and it is in the verge of completion. So we are, our residential house is in threat. Lordship. Yes, Lordship. I will produce by way of an additional affidavit. Lordship. Lordship. Lordship.
48.
Please, Lordship. Lordship, there is a case, my lord, it is settled position of law in terms of my lord order 20 rule 6, read with section 33. The degree must follow the judgment. But in this instant case, my lord, what happened? The degree which was set up on my lord compromise, my lord, the judgment which was set up on compromise, but degree contained the schedule something else, and that creates the problem for all parties concerned. Now, out of this situation, my lord, this instant revision we have filed. So, the thing is that, my lord, within 10 minutes, it's possible to take up this matter. Hello, the start of my lord, or lordship, fix a date for final disposal. Hello. My lord, what I'm saying, my lord, the issue is here, my lord. In terms of order 20 rule 6, read with section 33, a decree must follow the content of the judgment. But here is a case, my lord, where, my lord, the judgment was, my lord, set up on compromise. But the decree contained the schedule of the plaintiff, my lord, which is otherwise altered, my lord, by virtue of compromise. And out of which, my lord, what happened now, they are going to execute the decree against the, my lord, decree holder, my lord, by the decree holder itself. These are the legal issues there. My lord. Yes, my lord, it's indicate X, and out of lordship can you see that 35. But this is a deed of memorandum of settlement, and lordship kindly see the relevant part, my lord, contain my lord. My lord. My lord. Yes. Yes. Lordship, just look for page 38, the part of that compromise, 38 of my revision, sorry, my revision petition, Lordship, sorry, page 33 of my revision petition. Yes, madam. Yes, madam. This is the deed of agreement. Yes, madam. Here, madam, close to. That the first parties have agreed to give allotment of shop in new RCC building. Two constructed by Chabur Town Committee under 10% PF for any states to members of second party after construction of new shop premises. New market complex and second party members shall be entitled to get X shop premises on the ground floor as per the record of the town, Chabur Town Committee. That means, my lord, what happened that but my lord, get otherwise, my lord, we take it that there is no indication particular of that shop. Reason behind is that, my lord, earlier there was a construction and that has been, my lord, put on the challenge. Yes, absolutely. The diagram is there, my lord. The diagram, Chabur Town Committee is enclosed, and that has also been accepted by other side, my lord. Lordship, 84, my lord. Yes. My lord, kindly see that so far the 84 page is concerned. Yes, madam, no doubt. Absolutely, definitely. Now, Lordship, so far the diagram is concerned, we can see that 27 numbers of, my lord, degree hota. Right. 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 Quite right, madam. Right. My lord, I think that, my lord, so far the compromise deed is concerned, my lord. It is the arrangement between the both sides that once new construction is there, the authority, they have given the power to the authority to set up that which shop is entitled for the decree holder, my lord. And it was not objected at that point of time. And based on that, my lord, it has been converted into, my lord, decree. But decree contains the schedule of the plain, my lord, which otherwise nowhere in existence because the market itself has destroyed, my lord, and new construction was made. How they can now claim that the schedule which has been contained in earlier plain, equally to that, they have to entitled to get it out, my lord. My lord. Yes, my lord. Yes, my lord. My lord. Well, things that, my lord, yes, ma'am. The disputes, my lord, remains, ma'am. My, my, yes, ma'am. My lord, kindly see, yes, yes, quite right, my lord. I'm just trying to satisfy lordship to this point, my lord. The affidavit filed by the Chabur town committee is relevant here, my lord. And it was not opposed by them clearly, my lord. Lordship, affidavit filed by respondent number, my lord, one. One. Yes, ma'am, yes, ma'am. Now, lordship, kindly see the diagram which has been followed by even the rest parties who were also degree holder, my lord. Nobody is opposing except them 5 persons, my lord. 103 is the part of annexure, my lord. Plant diagram. Thereafter, my lord, this 104 is another diagram where existing and proposed of everything has been shown thereon. And it has not been opposed by them by that this diagram is not acceptable or whatever, my lord. There is only reply to that extent, my lord, from their side. No, my, against this, my lord, diagram which has been, my lord, which has been relied upon by the town committee, my lord. Yes, sir. Yes, ma'am. My lord. My lord. Yes. My lord. Lordship, kindly see so far the compromise deed is concerned, my lord. If we see from beginning to end, my lord, of the compromise deed, the language is very much clear that a new construction will take place, and based on that, my lord, the construction, whatever will come up, that will be shared by the respective parties, and preference will be given to the ground floor, etc., to the parties who are the part of litigation. Now, if we understood from that, my lord, the content of that deed of compromise, it clearly reveals, my lord, that the accommodation will be given to them up to the extent of possibility, my lord. My lord, it was not opposed by them, my lord. This is not a case, my lord. If we see their part, my lord, they are not in a such situation. My lord. That point of view, not because it was proposed to create a new construction. My lord, earlier there is an existing construction. Based on that, they approached before the civil court for the purpose of protection, my lord. That they should not be evicted or they should not be, my lord, suppose shifted to other. Thereafter, my lord, the compromise took place between the all parties concerned, saying in the area that a new construction will take place, out of which the accommodation will be made to the party in preferential site. And my lord, based on that, my lord, the 27 numbers of parties out of 22 has already been accommodated. Suppose I have been accommodated here, I am the decree holder. Now, how I can be evicted by another decree holder against me, my lord? If, my lord, it's a settled position of law. If suppose they have a dispute about the area, etc., my lord, they can go for a fresh suit, my lord. But so far my rights are conferred. Well, my rights how can be deprived? Because we are the persons who are also the part of decree holder. We possess certain area. Now they have got an order saying that my area I have to be evicted, my lord, and they have to be accommodated. But it's not a case alone that the decree is now going to be executed against the judgment debtor. Even it is a case of well, the decree is going to be executed against the decree holder itself. It's not a cross degree case, my lord. I'm the decree holder, my lord. We are the 5% of the decree holder equally entitled to get the benefits like 22 years, rest 22 numbers. They are the 5% who are deprived. They are saying that the Lordship kindly see where the problem actually comes from. Lordship, the decree contain one important aspect, Lordship kindly see. It clearly says compromise part, but the schedule has been contained which the part of plaintiff, my lord. It's a case of novation of contract, my lord. The entire thing has been now nearly altered, my lord. Section 62 of the contract also has certain role to play. Yes, ma'am. They have put their signature. Yes, yes, yes. Yes, ma'am. Yes, ma'am. Yes, let's just look for one degree, madam. Just only one more, madam. Page 39, madam. Degree. The line is that, madam, 39, the suit is disposed of on being compromised by the parties. The content of the, madam, my entitled actually what happened with construction later on takes place. Nobody knows that what area will be constructed. Then once this construction is over, then as per the accommodation that was earlier they have in that old market, the accommodation was made. And based on that, My lord, tomorrow, Lordship, can be next Tuesday, my lord, or Friday, my lord. Tomorrow, little problem, my lord, I have.
My lord, may I submit possible? Whole things, my lord, he is one of us, my lord. No, it reminisces the state of Dhurandhar, my lord. He is one of us. Now she is questioning the decree, my lord. Was it an application? My lord, the state of Dhurandhar film, my lord, just resembles the facts here, my lord. She is one of us, my lord. She is a decree holder. Now she questions here in a revision petition, my lord. She should have filed an application under 23 Rule 3, my lord. It was not done. Neither any questions was raised during the execution of the decree, my lord. And what happened? The whole problem started, my lord, because of the clandestine efforts of the municipal committee. What they did, my lord, the decree clearly says first the decree holder has to be accommodated, then the outsiders. Now they, my lord, they engage into negotiations. Outsider, my lord, hefty negotiations with the outsiders. They gave them allotment. Even FIR was filed against the ex-chairman, my lord. FIR was filed. Now, my lord, the whole thing has, my lord, come, my lord, given rise to a new situation, my lord. Now they are questioning the decree, my lord. They are a decree holder. Now, my lord, these 5 persons, they have been allotted a larger space in as per the old record. Now they have been given very small space, my lord. And she is continuity is not agreed because, my lord, she got the entitlement at our cost, my lord. Somebody else's, my lord, space has been given to her to accommodate her, my lord. Because that is why she is questioning now, my lord, before this honorable court. So, my lord, this case is not maintainable at all, my lord.
My lord, my place, then Lordship, I take up this next week, Tuesday, my lord.
Not next week, my lord. Friday, my lord.
Then Friday.
Friday, no. Yes, my lord.
Better to come in a hearing day, because all time very
No, my lord, the execution is being stayed by an order of the court is bench.
My lord. Tomorrow I have personal difficulty, that's why, my lord. Tomorrow only accommodation I sought for. That's why, my lord, next Tuesday, my lord, possible, my lord. What the NT model is there, my lord? Then, my lord, yes, my lord, no problem. Seven? Oh. 11, my lord? So there is NT model, my lord. NT model. All right.
Item number is 14, madam. Yes, madam. Yes, sir. Against the DRT order, madam. It will take time, my lord, to go through the evidence and all.
Yes, my lord. Yes, yes. Against the impugn order, my lord, that was passed by the Deputy Tribunal. My lord, yes, my lord, but when there is a provision that with the consent of the parties, when there is a consent of the party, then no appeal will lie. And the miscarriage of justice has been done, so it will only come under 227, my lord. Because section 21B clearly says, because the question is regarding the FSL report. The certified copy was sent for the FSL report, which is under objection. That he cannot send a certified copy. It should be the original copy. That is the issue here. Uh, 4 and 5. I'm appealing for the petitioner, my lord, Putko. Mr. Senior Counsel, my lord, is appearing for 4 and 5, and others are there. They have not appeared. The impugn order is, your lordship, page, and it's page 70, my lord.
71.
70. 701. Application. Mr. G is the objection, my lord, against the FSL report. That is page 59. Yes, ma'am. Earlier, Mr. A.C. Sharma was there. He has withdrawn his application. Later on, apparently. Yes. Yes. That is annexure 9. They have sent it, my lord. FSL report was sent. And when it report came in, we find that the person, the petition which they have sent is a certified copy, not the original documents. So that is, we have given the objection under section 59, my lord. That is annexure G, page 59. That is the objection. Even in the cross also, we have asked the FSL report, reporter in the inspector. Yes. 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 No, my lord. Original is with the DRT. Because at the time of filing the cases, my lord, original is to be there and they will keep in the custody. And they are supposed to send the report in original, but they have given the certified copy. On the certified copy, the respondent number 4 and 5 has signed it.
They're disturbing my learned friend mirror. They have proved that document. Signatures were proved. That document was sent. Not the other document.
Yes, you have to go by the record, my lord. In the cross of the FSL report, my lord, you'll find that he is admitted. This is a certified copy. And why we cannot make an appeal in the before the other forum because of the section 20 of 1 and section 21B. Because when it is with the consent, no appeal will lie. So we have to come under 227. That recovery tribunal. My lord. That order sheet was not annexed, my lord. The application was filed by the respondent number 4 and 5, my.
Well, they are the main contesting party, man. Their lands were mortgaged, madam.
The application is, my lord, 48, annexure D. And application of section 75, read with order 25, 26, rule 10A.
My lord, they have, on the certified copy, they put their signature. That signature differs with the original one. Original is with the custody of the DRT, which they ought to have said. My lord. Oh, these are not certified copy. Your lordship will go to the. No, my lord, original was never sent, my lord. That is admitted from the judgment itself also. The certified copy, we raised an objection to that.
Page 114, my lord. Along with our affidavit, my lord, we have filed the document. If it is a certified copy, my lord, and if the signatures are not original, how this, my lord, the seal of the party will come? That's why, my lord, the forensic expert said that the signatures are original and the document is a certified copy. And they have exhibited, my lord. That is not our document.
I have not exhibited. Yes, I have not exhibited, my lord. It is their petition. They have sought for that correction, my lord. FSL report. It is not our petition.
Document is your document.
Document, my lord, that's what I say. The original document was written by the DRT. And the photocopy certified copy, they have put the signature. Naturally, it will differ, my lord. That is our objection.
Your lordship may be pleased to see page 125 of our affidavit, my lord, which we have exhibited. They have exhibited, my lord, exhibit A1.
My lord. Then I will leave it to your lordship because so far the. Yes. Yes. Affidavit of. This is affidavit of the Utko, my lord. I am sir. I agree, my lord. What I am saying, my lord? Yes, yes. I agree, my lord. Your lordship was saying. Yes. 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 This is 1/2. Yes. Yes. But understood by letter, your lordship says it's original. Your lordship will see the cross of the FSL report. Then I'll leave it to your lordship. I have nothing to say then. Yes, my lord, and they have sent it. That's right, my lord, that is what I'm saying, my lord. And just to, your lordship will come to the cross of the FSL report, my lord. The inspector, what he has stated. Yes. No, I understand, I'll not. Yes, my lord. No, this is not my case, my lord. My lord, I'm just stating, my lord. At the time of filing the OA, my lord, we have to submit the original documents. Now, that much I'm selecting submit, my lord. During the evidence, we have submitted the original documents. It is in the custody of the DRT. Next, when they have filed a petition that certain documents has to be sent because they denied that it is not their signature. In the original, they said it is not their signature. They have filed a petition to send it to the FSL report. While sending the report to the FSL with the documents, they have given the certified copy. Original copy was not given. Original signature was not proved. And that is all evidence from where I will show you, lordship. Just bear me, lordship. Your lordship will come to the cross of the. I know if it is on the record, your lordship, also that the statement about the FSL. Yes. 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 I'm not disputing that, my lord. What I'm disputing that the documents which the DRT has sent to the FSL report, the original is with the DRT, my lord. Yes. No, with the DRT. No. It is with the DRT. We have to give all the record to the DRT. Yes, my lord. Original record is also to be submitted before the DRT. No, my lord. Yes, I'm confirmed. Today morning also I'll say there it is with the DRT. Then your lordship. But only this observation may be kindly taken, my lord, that in the cross-examination, the FSL report says my lord, my lord, DRT is to send the copy or we'll send the copy to the FSL report. Which is because it is on their prayer. No, my lord, what I'm saying, my lord, what I'm saying, we have not asked for sending the report to the FSL. It is a respondent. He have asked, filed the petition. We said we have no objection. Then DRT has sent the record to the FSL report.
Record only exhibited documents, madam,
Yes.
not other documents.
Yes. Yes. The original is with the DRT. Well, may I seek some time to get the clarification from the authority whether They have sent it the original. No, that is what I have been instructed. The original is the DRT. So your lordship will record my statement because I have to, yes.
If originally is available with the DRT, they would have exhibited that document. But
No, we have exhibited those documents. In our evidence, we have exhibited.
then
We have exhibited in our documents.
proved in original. Where is
Yes.
the proved in original? Yes.
That will be, my lord, we have, in our evidence, we have exhibited those documents and it was written by the DRT. My lord, I agree with the lordship's suggestion, but the thing is, my submission may be kindly recorded, that original, that, then your lordship will pass the order. Let's see, my lord, what the corporation.
Legal layers of respond number 4 and 5.
Yes.
Yes, yes, this, only this is good. In the cross also he is admitted that.
Page 69 of the report. Petition.
Page 69, your lordship. Page 69 of the petition. Cross examination. Yes, 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 yes. No, no.
One of the experts said he does not know whether it is an original document or certified copy.
Yes, yes, yes.
Next time,
Next time the cross. Let me, this, he admitted with the cross.
Yes, ma'am. Yes. My lord, if your lordship comes to the, if your lordship comes to the page 59. Yes, yes. That is what I'm saying. Yes.
My lord, the dispute is with regard to the exhibit A2 and A4. Yes, yes, my lord. Yes, sir. That, yes, sir. That is in page 59.
A10.
A10. A10 is a loan agreement.
One 22. One. Password 31. 31.
D.
31.
A2. D.
A4.
A2 and A4 are the certified. No, other, no objection. Only A2 and A4 are the original certified copy. Yes, yes.
A2, A4, A6,
6,
and
A9, A10,
A30.
and 31.
Passing of the order. So I had forwarded the exhibited documents to the forensic expert, which is evident from the fact that along with the forensic examination report, from the documents, the exhibited documents which are enclosed are found to have been separated from the evidence on affidavit, documents appended to, exhibited documents appended to the evidence on affidavit. The cost of repetition, it is mentioned that the bunch of documents which are sent to the forensic science laboratory contains the original documents and the documents referred above were copies. In this case, the petitioners, if the petitioner has not produced the, he has not annexed to this application the extract of the original mortgage register or memorandum of mortgage, by whatever name called. The petitioners are also not produced purported photocopies of the original of the so-called original documents, exhibited documents submitted before the learner debt recovery tribunal. Next paragraph, even assuming that the court is to believe the case what is projected by the petitioner corporation, it would mean that the debt recovery tribunal, or despite receiving the original of of exhibit A2, would create in its record a certified to be true copy issued by the senior sub-registrar office at Gauhati on 18/6/2005. A2, after A2, what is the document? A4. A4. And similarly, also substitute the original irrevocable power of attorney within bracket exhibit A4 with a certified to be true copy procured from the office of the senior sub-registrar Gauhati, issued on 18/6/2005. Then A10.
A9.
A9.
A6.
Then A6. After A6, what is A?
A9.
A9. it may be stated that there is no dispute with regard to the fact that the other referred documents being exhibit A4, A9, A4, A6,
A6,
A9,
A10,
A10,
A31.
A31 are in original and not certified copies. Therefore, the dispute is only with regard to the exhibited documents, two exhibited documents being exhibit A2 and exhibit A4. Which is most unlikely, as certified copies of the deed of agreement and suitable general power of attorney 18/6/2005 could not have been, it cannot be accepted to have been manufactured by the State Recovery Tribunal in substitution of the original documents. Accordingly, the challenge to the impugned order dated so and so. Accordingly, this next, the registry shall the travelers records along with a copy of this order to be made a part of record by the learned tribunal, learned recovery tribunal committee.
There is stay order, my lord, that may be.
Of the interim order staying the property of 0856 of 2012.
My lord,
Yes.
Sir, a date may kindly be fixed, my lord. August.
As both as the petitioner and the both sides are directed to appear before the death recovery tribunal on 22/6/2026 and by producing a certified copy of the order, wait for further orders that may be passed by the Central Tribunal.
Date for
22/6.
22/6.
My lord, actually, date may not be fixed, my lord, because
Because
after.
they will issue the
record,
notice.
they will issue.
You just appear there, the records will go. It may take 1 or 2 days, but they'll manage. For appearance, no notice will be required.
How like you?
The record will go. Doesn't take much
Because
time.
another problem is there, my lord, their substitution will be necessary there.
Those can be helped. Yes,
Good, yeah.
How like you?
Mr. Rajbir Bhuiya, you have been waiting for quite a long time. This is not a good time to take up this matters.
It may be taken up tomorrow or any other day.
Tomorrow it will not be listed.
Tomorrow may not be possible because
Only thing I will make a fair before the lawsuit, my lord. My landlord has filed an application and insisting on it. I request your lordship to dispose of the entire matter because it is a suit of 1990. It is degree, appeal dismissed,
No, I
second
thought-
appeal dismissed,
Obviously, file it before us, we can't say whether you can dispose it off.
and it is the fourth round in the CRP, my lord.
I am
So,
also
third
decree holder.
time, my lord.
They are also decree holder. Fight between decree holder.
Okay.
Only the final disposal of the matter.
Agree to a date. We won't say,
No, that,
Next week, my lord.
after,
On my side, won't be that good. On my side,
okay.
except that.
Agree to a date, just all of you just.
9th of June, my lord.
On 11th of June.
Is Mr. S. Bush, the Lion Counsel for the petitioner, Mr. M. H. Rajbodhia, the Lion Counsel for respondent number.
Phone number 1, 2, 3, and 4, my lord. That is one is dead and 2, 3, 4 is legal yet.
4, you are for?
I'm for 6 years.
S. Dasgupta, Lion Counsel for respondent number 6.
7.
Okay, whatever is your name. P.K. Basu on behalf of Mr. K. Viswas.
I'm for the
Lion Counsel appeals for respondent for 7.
I'm for the respondent 5.
Mr.
H. Purva.
H. Balwar, Lion Counsel appeals for respondent number
5.
5. Make it serial order, huh? 1, 2, 3. Are present. So when it is already 35 in the evening, the matter could not be heard. All sides, make a request for an early hearing. Next, I have agreed to by both sides, list the matter on
11, my lord.
No, agree to both of you. 10th, 11th, don't ask me.
11th of
Both of you,
11.
all of you answer. 11,
Let it be 11, my lord.
11, 6, 26.
For final disclosure,
I am not saying that because I can't commit.
My
You
lord,
know what is happening.
actually execution case is going
I
on.
understand.
That is what.
The bench will be taken up. You will have to make a request then. I can't commit for the bench now. You know what is happening. Otherwise, there is no point sitting till 5:40 here.
That's too much.
Much of.
No, my lord, we're all along observing your losses, sincerity and.
Much. All right.